Good.
Hey, so this, you guys, for those of you guys don't know, Bailey has been with me forever. Thank you, love, for the galaxy. Bailey has been with me absolutely forever. She has read, I believe, every single transcript with me. Let me explain something too before we get started. These transcripts are not easy to read. Okay, I want to explain that. Again, it's over 100 pages. 1. 2, it is a transcript, so it is written, every word, everything that everybody says is on here, okay? And we read it exactly as it's read. So a lot of times it makes it seem as if we're reading wrong or we don't know what we're saying because they'll be like, oh, and then what? So we're gonna do this. They don't even finish sentence. They talk over each other. It gets right. So if I see comments about the way people are reading whatever, then you can exit stage left, or you can pay the $480 and purchase them yourself. Right? So we're just going to keep it respectful. That's all I ask, is just be respectful. Okay? It's 3:06 a.m. Girl, where are you at? And shout out for being up, okay? Yeah, we are turning the comments off, but honey, they still come in and do it. Okay? Hey, Sip. All right. Are you ready, my love?
I am.
Okay. So, Amanda! I love every gift, but someone sends me their very first gift, it means a lot. Also, I want to let you guys know, I will not, obviously, comments will be off. I won't be able to thank you guys for gifts. If you guys send gifts while I'm coming on, I will thank you guys at the end. I just never want you guys to be like, damn, I sent her a gift and that bitch didn't say nothing. You know what I'm saying? So, just want to keep it cute. Okay. So, again, you're going to be the judge, at least for the beginning. We may switch in the middle, but I want to read the,
Yep.
the whatever she's called. Okay, and it's 101 pages. Let me see. This was on April 29th. I'll read the case information. This is John versus Bree. Honorable Nicole C. Bershon, judge. Reporter, time 41. Okay, I'll let you start.
Okay. On the record, in the DV Olson matter, may I have appearances, please?
Ms. Budnick, yes, good afternoon.
And appearances, please.
Ms. Budnick, good afternoon, Your Honor. Taylor Budnick for the petitioner John Giese. He is present at counsel table. Then Bree's attorney, Ms. Fonseca. Good afternoon, Lindsay Fonseca for respondent Brianna Lynn Olson. She is also present.
All right. And I'm going to ask, is it Dr. Leon Fuentes or Miss De Leon Fuentes?
Miss Leon Fuentes.
Okay. May I have Miss Leon?
Thank you. You guys, who's coming up now is the parental evaluator. This is the one that I meant to say this beforehand. They showed up. They had the evaluator sat with Bree and Baby W, 2K and Baby W, then Bree separately, 2K separately. Okay, so that's what you guys are going to hear. Okay. So she says, thank you.
You're welcome. May I have Miss Leon Fuentes, Mr. Giese, and Miss Olson all raise your right hands, please? Whoever just came on, Michael, you need to get off. Whoever is on. Okay, go ahead.
The clerk, please raise your right hand to be sworn. Well, we don't need to read the sworn in stuff. Called as witness. Okay.
All right.
Here, Julian sworn as testified. Gotcha.
All right. Okay. You need her to state her name and spell it?
Yes,
and the clerk.
Please. Oh, sorry. Go ahead.
Yes, please state your name. And then the judge, viewer, you need to get off. Okay.
You guys, I can say right now, this is gonna be this one thing is gonna be frustrating. Apparently, I'm seeing already beginning. This is when randoms were trying to pop into this case. This is why I preach all the time. Don't show up to their cases. This is crazy. Okay. The witness. Good afternoon. My name is Cynthia de Leon Fuentes. Would you like me to spell my name for the record?
Sure. Then the clerk, thank you.
Witness. Was that a sure?
The judge, yes, please.
Okay, so De Leon is spelled D-E space L-E-O-N hyphen Fuentes F-U-E-N-T-E-S.
Miss De Leon Fuentes. Sorry, guys, I'm very white.
Oh,
That was me. That was my wording.
Oh my god. You can just call her Miss F or Miss De Leon, whatever.
And
And
then,
okay, go ahead.
sorry, the clerk, is that LPSW or
I'm an LMFW.
Miss F? Are you in the building or are you off site?
I am not in the building, Your Honor.
No, that's fine. Otherwise, we'd have you come in so we could get offline. But as soon she's done with the questioning, we're not going to have any more remote proceedings. All right? I don't want to spend too much time. I had an opportunity to review the report. Have you, Miss Fonseca?
Ms. Fonska. Yes, we reviewed it before we had our 11:30 meeting.
And have you, Miss Budnick?
I have.
I see that I'm not going to have to ask about stipulations. Do you don't stipulate, right, to the report?
Neither of us, this Ms. Fonseca, neither of us stipulated to the court in full.
And that's true.
Ms. Budnick Taylor, so this is John's attorney. We largely stipulate to this report.
Neither. So we need to hear from her, obviously.
Ms. Budnick, yes.
Go ahead then, Miss F. The floor is yours.
Thank you, Your Honor.
You need to get off. Rodriguez, go ahead.
It's Miss De Leon Fuentes. Okay, Your Honor, I will proceed with my testimony. Is that correct?
Yes, you may. The reason why, and I apologize, these proceedings have been broadcasted live. Transcripts have been posted online. That's why we're removing people when they log on because we don't know if they're broadcasting live. So I apologize. There is going to be interruptions. Please forgive the court in advance.
Thank you, Your Honor. All right, so again, good afternoon.
Hold on. Then the clerk. She can go ahead, Your Honor. I'm on it. The court. Michael has it. Go ahead, Miss F.
Mind you guys, all of these interruptions are because people keep trying to join their thing online. Crazy. Okay, Ms. Dingham. Thank you. As everyone knows, this morning I concluded the parenting assessment for the case that happens today. And again, due to the nature of constraints of the information that I am providing today here is limited on time and scope. At issue before the court is the disputed custody and visitation plan for the minor, baby's name, is it Geesey, I believe. And then John, yes, ma'am.
Okay, thank you. Whose date of birth is
Okay, but make sure
we
we don't do that. And then there's going to be also some teachers' names and doctors' names. Make sure we skip over that too. Okay, sorry.
Yeah, no, you're good. This assessment did include individual input. I think this is.
No, this is still the. Oh, maybe she just didn't flip back. Okay, it is. I will do that. Okay, I'll read it. Okay, this assessment did include individual in-person interviews with each of the parents. Those lasted approximately 80 to 90 minutes each. It also included observations of the minor with each parent. Those lasted about 5 to 10 minutes each. I did not interview the minor. He just recently turned 2, and his capabilities with capability was a bit limited at that time. I also want to note that the minor was not feeling well. He did seem to become progressively more sick as the day continued in the courthouse yesterday. So, in preparation for this parenting plan assessment, I was able to review a lot of the legal file in Odyssey. I also was able to review the parenting questionnaires that each of the parents filled out and followed the court's instructions, which dated the specifics of the case with father living in Texas and mother having an active DVRO against her. I reviewed records from the California Department of Justice concerning each of the parents. And I also conducted brief telephone interviews with the maternal grandmother. I'll leave her name out. The paternal grandmother, Mama 2K, the director of where the minor's in school, and that individual's name is, I'll skip that, and with mother's fiance, Santos. So it is my understanding that as of August 2025,
And then Bree's attorney, Your Honor, I'm sorry. Then the judge, yes, hold on a second. Then Bree's attorney, we've been really careful not to say the facilities. Then the judge, all right, I will, yes, let me ask. I don't know if we are able to do this. Can you strike the name of the daycare center from the record? And then the court reporter, okay. Then Bree's attorney, thank you so much. Then the judge, thank you. Go ahead.
my apologies for that. Thank you. I will make a mental note not to mention the name of the facility moving forward.
And then the judge, thank you.
So it is my understanding that as of August 2025, father has had sole legal custody of the minor and primary custody in the state of Texas. Mother had had 1 week of liberalized visitation in in Dallas County and the surrounding counties since this order was made. Now, in meeting with the parents, they both report that they met around 2021 through social media. They dated for approximately 10 months, and then mother became pregnant with the minor after the parties had entered the relationship. Both refer to the relationship as quote unquote toxic. Both stated that there were abusive behaviors that were perpetrated by the other person. Now, with respect to the reasons for the separation, father's perspective is that mother was physically assaulting him. And by this, he stated that she was hitting him. She would sit on him. He would also state that mother had been unfaithful to him. Now, mother's perspective, again, is the relationship was quote unquote toxic and that they had been on and off throughout much of their relationship. She stated that with the announcement of the pregnancy, father did not want to be a part of it. Now, in meeting with the father, he informed me that he lives in Texas. He lives in a 5-bedroom house that he shares with the minor and his mother. He's been there a little less than a year, and prior to that, he was residing with his mother in a different home, which is also in Texas. He said that he moved back in with his mother, after being awarded custody of W. For work, he is a content creator and real estate developer. He stated that he started doing content creation in late 2020, and more specific, he has a flexible work schedule that allows him to work from home. He typically works between 9 a.m. and 2 p.m., and again between 5 p.m. and into the later hours of the evening during the week. He does not have a significant other, and his current support system consists of his mother and his family who live in Texas. He did share that he does have a relationship with a couple of mother's family members, particularly a cousin and aunt who live within the Texas and around Dallas. With respect to substance abuse, he stated that he does sometimes smoke cigarettes, but he denied smoking when the minor is around him. I did ask him questions about mental health, particular any prior mental health treatment. He shares that he is currently not in therapy, but at one point while he and mother were dating, he did attend one individual therapy session. He said that he had attended because mother suggested that he go to therapy, and he added, quote, she, referring to the mother, said, I needed therapy. And then she told me not to go back because the therapist was crazy because she was talking about her, end quote. Father did share his concerns about the case. His first concern is that he says that the mother is not truthful about W's location during her parenting time. Added, quote, she lied about San Antonio, Corpus, and she lied about where W is in Dallas. It's also about her dishonesty about her location, end quote. When I checked in with Mother about this concern, she said that the father has expressed these concerns to her before, and she does acknowledge there was an incident in which she flew with the minor from Dallas back to Los Angeles, and it resulted in a police standoff. She said, quote, the closest thing was when I flew from LA to Corpus. At that time, it was early, and there was no other to fly with him no order to fly with him out of state. In March, I flew him here, and I wasn't supposed to. I did it because I didn't want to be in Dallas in a random hotel with my son. At the time, my thought was that I wanted to be in the comfort of my home, and I was tired of doing my visits in Dallas. I felt that we couldn't bond, end quote. I asked Mother to share more about her thoughts about the court orders that have been put into place. She said, quote, I didn't have a lawyer, so I don't know if I knew about a specific court order. I was misinformed at the time. I knew it wouldn't go well, and I suffered from consequences for not by getting monitored supervised visitations. The other incident that John, is concerned about. I had asked him prior if I could take W to see my mom in Corpus. He said no, because the court order stated that I needed to stay in Dallas, and I felt like it was unfair. I felt like he was being difficult about something so little. I took W to San Antonio to my fiance's family. I didn't want to be alone. I tried to go through the lawyers and through John on our family wizard, and I wanted him to agree, but he wouldn't. He was being very strict, and it was the holidays, end quote. Let me just say, listen, this is just my side piece. Again, this is part of the problem, right? To where I'm glad she's being honest and she's speaking about this, because she's legitimately telling them it's going to be I don't care what he says. I'll ask. I'll follow that. I'm going to ask. But even if they say no, I'm just going to take my kid wherever I want to. Okay. Back on. Okay. Father's second concern is Mother's fiance, particularly him not being around the minor. He stated that Mother's fiance uses rugs and that he has a preference for him to not spend time around the minor. When I checked in with Mother about this, she acknowledges that there is tension between her fiance and the father, and that him not being allowed to be around the minor has added to the tension. And it says discussion off the record between the court and the clerk. Okay.
And then the judge, sorry.
That's okay. She also stated that he makes accusations about her and her fiance all the time, and that she does not know where these accusations are coming from. Stop it, Brie. Father's third concern is Mother's acts of domestic violence. He shared that the court recently made 3 findings earlier this week. One was against him, one was against her current partner, and the last is a violation of the court order when she took the minor to San Antonio. Oh, remember I told you guys that there was a third. That's what it was. It's when she took W on her last visit to San Antonio. That was the third one. Okay. So let me just read that part again. Okay. One was against him. One is against her current partner, Santos. And the last is the violation of the court order when she took the minor to San Antonio last year. Now, to this, Mother acknowledges Father's concern is valid, and she described that the incident of domestic violence found against her towards her current partner involved her, quote, pushing the shoulders, end quote. And she added, quote, the judge explained that there are circumstances and it's not domestic violence. but she said that that type of allegation or altercation is domestic violence, end quote. She denied engaging in domestic violence with her current partner, and she added, quote, "This is not what's happening behind closed doors," end quote. Well, Bree, it may not be happening behind closed doors, but it's surely happening on camera in front of all of us. Back to this. Now, mother informed me she currently lives in Koreatown. Sorry. Whatever. Well, I won't read the rest of that. She also informed me that her and her fiance moved into this 3-bedroom apartment just last week. Prior to the move, her and her fiance lived in Lancaster. They lived there for about 4 months, but she said that the home was too far for them in terms of the location where they needed to be, and so they decided to relocate back to Los Angeles. Prior to the move to Lancaster, she was living in West Hollywood. She lived there for about 6 months. Then prior to that, she was living in a content house, in between a content house and apartment, which is in downtown. She shared that there is discussion about her mother, the maternal grandmother, moving in with them here in Los Angeles. Stop it. But that's going to depend on the outcome of the court. She also described herself as a content creator and a live streamer. She shared that she is home most of the time. She actually described it as a home full-time. What? She also described it as home full-time, and she is in the process of developing a beauty brand. She has been doing content creation for about 5 years now, and she does not have a set work schedule. I also asked the question about her mental health, and she is currently not in therapy. She did share that she participated in therapy when she was a minor. It was due to issues when she was in school. She also told me, as to date, she has completed 2 parenting classes, and this was last year. I asked more questions about her current partner, and she told me that they've been dating for about a year now. I asked her to describe the relationship to me, and she said, quote, "It's getting better." Also, people have described it as chaotic. Some people have described it as chaotic. The judge, because of the things she's seen, end quote. She shared that since becoming engaged, they have been focusing and settling down and maintaining the court issues. I asked her to tell me about her understanding as to why Mr. Salazar is not permitted to be around W. She shared that the DVRO was granted was due to an altercation about something that had occurred between the father and her fiance at a hotel last year in July. I asked her when was the last time that Mr. Salazar was around W, and she shared that the only time Mr. Salazar had been around the minor was when she flew the minor to LA from Dallas for her visits in 20 something. And judge.
Your last testimony, hold on. There's someone on. Nicole, please log off. Nicole, please log off. Okay. You mentioned she said that Miss Olson, the respondent, said the last time her fiance Santos was around W was when she brought him home to LA, and you didn't say the year. That got cut off.
Yes, thank you, Your Honor. That was from her visit in 2025.
Okay, go ahead.
From LA, when she brought him from Dallas. So they're talking about the MILF house situation. We all know that's not the only time he was around.
Okay.
Sorry. She also shared that when she took the minor to Mr. Salazar's home in San Antonio this past Christmas, Mr. Salazar himself was not present because he was visiting his daughter, who also lives in San Antonio. I did want to know more about the kind of relationship that mother and Mr. Salazar have. And I asked her about incidences of domestic violence and police involvement. She denied any incidents of domestic violence and police involvement.
And then discussion off the record between the court and the clerk. Then the judge. Okay, sorry. Who was the target? Michael? Sorry, go ahead.
That's okay, thank you. So I did check in with the mother about her concerns, and she has two concerns. Her first concern is the decision making aspect for W. She has expressed her concerns about, excuse me, she has expressed her concerns, and she says that they've been received with, quote, he had full legal custody and you don't get to make decisions, end quote. I asked father about this, and he stated that the judge was response to the mother. He added, quote, I don't leave her out of anything. Anything that I do is for W's best interest. She is not around, and it's not appropriate for her to say that, end quote. Mother's second concern is literally the amount of time she gets to spend with W. She specifically states that she's only permitted to see him for 1 week, and it's a schedule that is equal to both of the parties. She added, quote, you can both get enough time and he can adjust to having two households. The visits being in Dallas is hard and will become harder because of the newborn. I'm supposed to uproot with my newborn every month to a state where I don't have any family, end quote. Oh my God. Her mom's not family, I guess. And so father stated that mother does have family. And he is referring to her aunt and a cousin that live within an hour of Dallas. He added, quote, so it's not easy for her to, sorry. He added, quote, so it's easy for her to break court orders and bring him to Corpus when she doesn't have W. She would go to Texas plenty of times. She chose to get pregnant and she chose to not come see W, end quote. Now, as I mentioned earlier, I was not able to interview W because of the age and limited verbal ability. And as I mentioned earlier, again, W was also sick and he was appearing to become progressively more physically uncomfortable as the morning progressed in the courthouse. Sorry, pause. That pisses me off to read that she's noting how sick he was and he was getting worse, and she still chose after court to take him around people that he doesn't even know and chuck balloons at his face for 2 hours. Okay, back to reading. That pisses me off. However, with respect to school, earlier I mentioned that he has been enrolled in school since January of 26. Currently, he is attending that school 5 days a week for about 5 hours a day. I was able to speak with the director of the school. If you like, I can state her name, but I'll just continue.
I don't think we need her name.
Thank you. She did share that since W began attending this academy, she has observed much more progress as he's more shy and that he's opened more with time. She described him as, quote, a happy child who is coming out of his shell, end quote. Love that. She stated that he's also saying more words and also denied having any concerns about his speech and development. Let me read that again for the pictures in the back. This is the director of W school. She stated that he's also saying more words, and she denied having any concerns about his speech or his development. She added, quote, Dad has asked me about my thoughts on this. I have done this for more than 20 years as a teacher, and we don't see any delays. He is a typical young 2-year-old, end quote. She stated that she typically has contact with father and with the paternal grandmother, Mom 2K. And she added, quote, I have talked to Mom twice, and I was cussed out both times. This is still the director. Let me read that again. Hold on, let me take a drink. She says, she stated that she typically has contact with the father and with paternal grandmother. And she added, quote, I have talked to Mom twice, and I was cussed out both times. She wanted me to give her credentials to sign on and to see the live cameras, and I told her that I cannot give her that information over the phone. She has to come, excuse me, she has to come and get it, end quote. The director then stated that mother's behavior on the phone could have gotten the minor removed from the school because they have a policy. Crazy. They have a policy on respect in their handbook about situations like this. She shared that the mother called the school. She was specifically asking for the live camera and not the parenting app. She also stated that they have a policy about not recording or taking screenshots of the live stream, as the parent's account can be suspended for 30 days if this is done. Now, with respect to health and development for W, mother did share that in January of 2026, the minor did receive a referral for speech.
Hold on a second. Hold on a second. Then discussion off the record between the court and the clerk. Then the judge. Okay, go ahead.
Thank you. Mother did express, she said that during the January 2026 medical appointment, the minor did receive a referral for speech evaluation from his current pediatrician. She stated this referral came about because she had expressed concerns about W's limited speech. She is just wanting an evaluation conducted.
Hold on a second. Hold on. Okay, sorry.
That's okay. And she stated on the day of appointment that the pediatrician was also in agreement with her concerns, as the minor had not spoken during that particular appointment. She said, quote, John is supposed to get a call about an evaluation. John later said there were no concerns from the pediatrician. When the referral came to John for scheduling, he said he would handle it, and based on what he said to the person, I don't know what he said, they didn't see a need for an evaluation, end quote. Now, Dad shared that in June 2026 appointment, mother did share an observation of the minor with the pediatrician. He added, quote, the doctor's name, said that if she was concerned, early prevention is a good thing. And he said that if you wanted to do it, you can, and they would reach out, end quote. He explained to me that he received a call from.
Wait.
He explained to me.
Oh gosh. And then, Max Sully, please log off. This isn't the first time either. Then Bree's attorney.
Oh, sorry, go ahead.
Bree's attorney. Is there a way where you can automatically put them in the waiting room and then he's prompted to admit them? Then the judge. Michael is working. Then I'll.
Oh, may I have a suggestion, Your Honor?
Yes.
What if we all get placed in a breakout room that would be private from here? Is that something we can do?
I'm going to ask Michael. Then John's attorney. Excellent idea.
That's how I hold my mediations, so I thought it would help.
Then the judge. That's a great idea. Well, while we're doing that, once she's done, are you two planning on calling each one of your respective clients? Then John's attorney, I think, and I can elaborate once she's finished, but the narrow issue that I just want to be heard on, I think I just need to make an argument. I don't need to call my client because we're not challenging. No. I mean, obviously I'll do cross-examination if she calls him. Then the judge, you're planning on calling your client? Then Bree's attorney, cross-examine and or oral argument, but no, not at this time. Then the judge, any other witnesses? Then John's attorney, no, Your Honor. Then Bree's attorney, no. Then the judge, and then the issues. Again, I'm just thinking about about this regarding whether this is permanent, not Montenegro. I think one of the things I wanted you both to think about, and maybe at the break you can think and we'll talk about it. I've been thinking about this. Doing a written order is going to take a while and all that. Sorry, I'm not on my usual.
You're good,
I
love. You're
usually have
doing a
it
great
downloaded.
job.
Doing a written order is going to take a while and all that, but I will be prepared. Maybe not today because I have to process everything, and I literally just got the PPA and I reviewed it and all that, and also the ex partes at lunch. That maybe give an oral pronouncement in a couple of days, we can just log on and whenever we get some time regarding my findings, and that will be my order. We'll hopefully have a court reporter so I don't have to write it up. But when I'm doing that, and maybe you want to think about in between now and the break, whether you want to stipulate that the custody orders will be the final orders. And my sense is that's probably not going to happen, but I want to offer this as an opportunity. And then if you don't stipulate, then most likely you'll have to go to trial on everything, including custody and visitation. I'll be ruling on the move away, but it won't necessarily become the permanent unless the parties stipulate that whatever order I make, the PPA is the final order. Then John's attorney, not necessarily. And I have some case law, and maybe it's helpful. I can give the court site. And then the judge, why don't you give it to me now and then I can research? Then John's attorney, sure, there are cases and there are many cases, but this is one that I think describes the issue best. Enrique M. versus Angelina Z. And then it lists that it's a 2004 case, but basically it highlights the distinction between what constitutes a final order. And whenever the court conducts a contested hearing, evidentiary hearing on best interest that amounts to the appealable order. Final orders are appealable. And this case kind of, I think in a very well worded way, very easy to understand, best describes the difference between what is final and what isn't final. It even addresses a case where there were orders after hearing pre-final judgment, and those are final orders. And it also discusses the distinction I noted on Tuesday, which is that where is a difference between then the judge. I'll give you guys a moment if you want to talk, but I can't talk and then have you talk and then so if you need a moment and then discussion off record between the court and the clerk, then the judge. My understanding is Miss F is we can go into a waiting room. We just have to restart. Discussion off record between the court and the clerk. The court. So hold on. Hold on. Hold on. Sorry, this is really hard with a lot of stuff going on. Then discussion off record between the court and the clerk. Then the judge. So Michael is going to log us back on, and put us into a waiting room. And in the meantime, if you just hang tight with us, Miss F will talk about some of these housekeeping. Does that make sense?
Okay, so just wait here and then I don't have to log back in.
Then the judge, no, just wait there. Okay.
Okay, go ahead.
And then John's attorney. So, anyways, I found this specific case, to be very helpful. And again, then the judge, hold on. Carly, please log off. Carly, please log off.
You guys, this is crazy the amount of times that people are trying to log on to this case. Like, let these people, like, stop doing that. Do you want me to, since this is the attorneys and judgment, do you want me to pick up the attorney's pieces for you?
Sure.
Okay. So John's attorney, And I read a bunch of cases, and they all say the same thing. The distinction is the schedule, right? Parenting time orders, short of a change of custody, can be modified based on the best interest at any time. The actual custody determination, if there is a contested adjudication of custody, and the court then makes a determination of best interest after that initial best interest determination. Every other request to modify custody requires a showing of change of circumstance, regardless if this is an order after hearing or an order and a judgment.
Then the judge, viewer, can you please log off? I guess my question, though, to you is, oh, is it? I think it is. Michael, it says the meeting is locked. Then the clerk, yes, it is. Then the judge, okay, hold that thought. I want to keep with Miss F. I want to hear back from you, but I want to review that with testimony. Okay, go ahead, Miss F. I don't think we're going to have any other people joining us remotely. So last you left, I think you were talking about Dr. said regarding, Dr. Blank said regarding if Miss Olson is concerned. Early prevention is a good thing.
Okay, now I'm back to Dr. F. Yes, thank you. So Father stated that he had received a call about this referral, and that was in late January or early February of this year. And we had asked him about the concerns. We informed him about Mother's concern, and because the minor predominantly resides with him, and he himself does have, and he himself does not have the same concern, the center decided that they would not be going out to assess the minor. Father was not able to recall the name of the person that he spoke to during this conversation. I made an attempt to reach out to Dr. Blank, but I was not able to reach him. I also attempted to reach out to name redacted from the court, but I was not able to speak to them either.
Then Bree's attorney, can we strike that as well? Then the judge, okay, strike the last.
Oh, sorry. All right. Okay. All right. So I was able to spend a few minutes with each of the parents with the minor. Again, the minor wasn't feeling well, and the observations were cut short so that the father could take the minor to receive appropriate medical care. When I observed the minor with father, the minor was cradled in father's arms. He was crying, and he was tugging at I believe his right ear. Father tried to get him to calm down by playing Backstreet Boys on the video on the phone. Father rocked the minor back and forth, and then he tried to soothe him. The minor was able to calm down, but he continued to rub his dad's ear. Father was not able to sit down because the minor would cry. I'm going to break in. I promise not to break in too many times, but every single time this baby flies to California for a visit or for a court hearing, he ends up sick and with ear issues. Like, I don't understand why that needs to continue. That's crazy to me. But anyways, I was able to spend at least 5 minutes with dad. It wasn't an ideal amount of time. We did transition to then observing him with mother, keeping in mind that he would be taken to the doctor immediately following the observation. Thank you. In doing that, the paternal grandmother assisted by bringing the minor into the room and handing over to the mother. The minor initially cried, and he did have a reaction to being separated from father and his grandmother. However, the mother was able to soothe the minor. She carried him, she cradled him in her arms, and she had a bottle of apple juice ready for him. I don't know if she means bottle or a sippy cup, but giving a 2-year-old a bottle. Crazy. Anyways, she was able to quiet him down and appeared very comfortable in mother's arms. Mother had toys for him, and she brought them out to entertain him, and he continued to be cradled in her arms. Now, although the minor did have a reaction to being separated from paternal grandmother and father, he was receptive to mother's affection, and he appeared to be comfortable in her presence and in her arms. Thank you, Nate. Now, it's frustrating that he got that reaction and he was fine with her, and then she just chooses to not continue. You know what I'm saying? Anyways, as I mentioned earlier, I did speak with a number of different collaterals. I'll briefly share some of the information I obtained from them. So the first one I spoke to was the maternal grandma, so Bree's grandma. Bree's mom. Her name is. She informed me that she currently resides in Corpus Christi, and she last spent time with W on Mother's Day last year during one of Mother's visits to Texas. She has not had any other face-to-face contact, in-person contact, with the minor. She does report that towards the end of last year, she did reach out to father via text about wanting to be a part of W's life, but the father did not respond. She described her relationship with mother as, quote, a good relationship, end quote. And she shared that mother will send for her to be flown to LA for visits, and that she does plan to be present for the birth of the new child.
Newsflash, she wasn't.
Yeah. They also had discussed the idea of her relocating to Los Angeles to live with her mother, but that would happen after the new baby is born and after court has made the decision on W's custody. Now, with respect of the relationship, her personal relationship with father, the maternal grandmother, she informed me that she met him once, and it was at the hospital when W was born. She says that they get along well, and that before she left the hospital, father asked her for advice on what he should do about court and custody for winter. She added, quote, I told him it was up to them. He said he would serve her papers, and I didn't say anything to Brianna, and I left it alone, end quote. I asked her what information she knew about their relationship while they were together. And she said, quote, Brianna would say it was toxic and that he was abusive, and he would yell at her. Most of it I saw on TikTok, but I never really knew their dynamic. She wouldn't tell me. Wait, what happened? She wouldn't tell me the ins and outs of the relationship, end quote. The grandmother did state that even though mother would post about being in an abusive relationship and a toxic relationship on her TikTok, this was never addressed in their private conversation. I asked her to share any observations she's made with respect to the mother in her current relationship, and she said, quote, I love them together, end quote. I asked if she had any concerns about abuse between mother and the current boyfriend. She denied and said, quote, he's a good guy, end quote.
Where?
What? Okay. Mind you, she's not been around, right? She has not been around them. Now, I did speak with the paternal grandmother, Mama 2K. She informed me that she assists father with the care of W when he is working. She referred to herself as, quote, his backup, end quote. When it comes to assisting with W's daily needs, she shares that after father was granted custody of W, she quit her job to help father full-time with W's care. And I asked her about the relationship with mother, and she shared that initially she had offered mother and the minor to go and stay with her after W was born so that she could recover postpartum, and that would have been in Texas. She described the majority of the in-person interaction was, quote, cordial and brief, end quote. And she informed me that she had met mother while she and father had dated, and that she did not approve of their relationship. She recalled that she would hear father arguing with mother over FaceTime late into the night while they were dating. She shared that regarding yesterday's visit between Mother and W, she had offered to hold a visit at the hotel where she and Father were staying for the purpose of being close by to help if the mother needed it, end quote. Or adding quote, sorry. I offered to have her visit at the hotel so she doesn't have to carry baby gear. I would be nearby in case Mother needed something, but she was not open to it, end quote. I asked her if she ever had any knowledge of abuse or violence between Mother and Father while they were together, and she said, quote, I didn't know about that. They would yell, but I didn't think of domestic violence, end quote. I also spoke with Mother's fiance, Santos. He informed me that he and Mother have been in a relationship for about a year. He said that they met through work. He said they met through work. And Mr. Salazar stated that he does marketing for social media influencers. He recalls that they were friends for 2 to 3 years before dating. They are currently living together and they've become engaged last year after Mother's pregnancy. He stated that he met the minor once when Mother brought him to Los Angeles back in 2025, and since then, he's only seen him through FaceTime, adding, quote, he recognizes my voice now, end quote. So he's basically just admitted there that he actually, well, we all know he's been around the child, but that he's actually been there via FaceTime videos, which actually is in the order that he's also not supposed to do. But do you, boo? He stated that he has traveled with Mother to Dallas to help her with lodging, but he denied being around the minor during any of these visits. He shared that he would like to be more involved in the minor's life. I asked him if he understood why the court had ordered him to not be around the minor. He said, quote, John lied about me. He provoked, oh my God. He's saying John, provokes and instigates. I keep it peaceful, end quote. Oh! Okay, we can turn on the, well, let me finish this statement and then we can turn on the comments for a quick little break. Y'all, I can't. He shared that through parenting classes, he has been able to demonstrate to the court that he and Mother are able to grow and adjust to court orders. You've broke everyone so far. He added, quote, we are not bad people. We want our family together, end quote. He shared that co-parenting classes have also shown him that many parents go through several conflicts and the importance of moving through this is conflicts. Okay, I'm going to read all of Santos's part and then we'll go because I know there's more so it's going to be irritated. I also asked him if he has children of his own. And he shared that he does. He has a 3-year-old who lives in Texas. Weird, both kids live in Texas. I asked, are you able to spend time with her? He said, quote, right now I get to visit her once in a while, like once a month.
Lies.
In quote, what? He's just straight up lying. Okay. He shared that since Mother became pregnant, he has focused on helping her, and he reiterated that he does have a parenting schedule with his daughter, but that he does not want her flying to Los Angeles. Quote, oh my God. Adding, quote, I don't want her flying right now. I find it dangerous, and I would rather go visit her in her environment. I do plan on her coming this year for her 3rd birthday, end quote. Oh my
He
God,
just said she was 3, and now she's turning 3.
right.
He doesn't even know the age of his own child.
Yeah, forget all of that, but for him, okay, can we turn the comments back on really fast? Because I want you guys involved in this. How crazy is it that Bree's fighting to not have to travel to Texas at all? However, Santos says, when he lied and said he gets to see his child every month. What? Right? 2, And it's crazy that that's a responsible, his answer is a responsible answer, right? He shared, but his son's mother's pregnant. Here it is. Okay. That he does have a parenting schedule with his daughter, but that he does not want her flying out of Los Angeles, adding, quote, I don't want her flying right now. I find it dangerous. But you want baby W to? You want baby W to travel every single month. And I think that this is a huge part, right? If you guys have seen, I think Dramatic Tea Talk posted up how sick baby W was when she took the baby, to California, and they were supposed to be in Texas. It was 17 hours of flying in a matter of 5 days span or whatever, and he had horrible ear issues. John had to take him immediately to the doctor. They fly into California, boom, next day after flying, have to go immediately to the doctor. It's crazy to me that all of that, I can't. Yeah, exactly. Lies. Once a month, he hasn't seen his daughter in how long? So, okay, I just want to take a quick little break. So I want to make sure you guys are, thank you, love. You guys are here witnessing all of this. We're going to keep going because we're only on page 29 of 101. Okay, you guys can turn back off. I'm going to keep reading. That blew my mind. Okay, I asked him about the relationship with the mother. He described it as a good relationship. He denied any instances of abuse, adding, quote, everything has been on camera, but it's all skits. So we do skits about domestic violence, and that's cool. Got you. He said that because of the court, he don't want to show that type of behavior. We're acting, end quote. He denied ever being involved. So the whole statement doesn't make sense. He also, thank you guys. He also denied any prior arrest.
And survey says lies.
Yeah, okay, sorry, let me just go. He also denied any prior arrests or detainments since being in a relationship with his mother. Apparently, Catalina Island doesn't matter. I did have an opportunity to review Mr. Salazar's, the CLETs, and it indicated arrest in Catalina Island in June of 2025. Interesting. Mr. Salazar was not forthcoming about this incident, but mother did disclose that he was arrested in Catalina Island on Father's Day weekend, which does coincide with the Cletus report on Salazar. Your Honor, in reviewing and in speaking with the parties and reviewing all of the information and speaking with the collaterals, there is a lot going on in this case. I think we all know that. It's also very hold please. Sorry. You guys can turn the comments back on really fast, okay? Because I have to make sure everything's okay. Hold on, my daughter just called. Hold on, I'm gonna mute real fast. If you want to turn the comments on, you guys can chit chat for a second.
Didn't Bree's mom see W on Thanksgiving? Yeah, this will be posted on YouTube, she said. No, she doesn't have a new lawyer. That's what I thought.
Sorry, it was my grandbaby.
Oh,
She wanted grandma. Okay, but I'm like, not today, honey. Okay. Let me get back to where I was. I apologize, guys. Whenever the kids call, listen, I gotta answer because, you know.
because you're a good mom.
Okay, here we go. Are we ready? I'm gonna start back at the where she's talking to the Your Honor. Again, this is still part of the evaluator. This is her. Right, cowboy. This is her giving the the whatever. Your Honor, in reviewing and speaking with the parties and reviewing all of the information and speaking with the collaterals, there is a lot going on in this case. I think we all know that. It's also very apparent both parents care about the minor. And then both have a desire to be an active part of his life. We have very differing viewpoints about parenting. And we also have very different interpretations about court orders as it pertains to their parenting rights. Now, in observing the minor with each of the parents, again, he did seem comfortable and securely attached to both. Mother displayed patience and patience and an ability to soothe the minor at a time when he was physically uncomfortable. She did not see, or she had not seen the minor in more than 3 months, and she was able to soothe him. This is a huge positive in terms of their relationship and to their attachment. The minor has been living primarily in Texas with the father since October of 2024. And he has a strong support system there, and it is now enrolled in school. I am recommending that he remains in Texas with the father, and that the mother continue to have up to 1 week of unsupervised visits with the minor in Dallas or in Corpus Christi, where her family resides. I'm also continuing to recommend that mother's fiance, Mr. Salazar, not be permitted to be present for mother's visits with the minor. The court did recently make a domestic violence finding that involves mother and Mr. Salazar. While both of them are denying engaging in any domestic violence, the information documented by the courts indicates otherwise. Mother also confirmed that Mr. Salazar was arrested in Catalina Island last year, and it was in the Cletus report that I reviewed for him. Now, keeping the minor's best interest in mind, I cannot recommend that Mr. Salazar be allowed to be present for mother's parenting time, because mother has a history of violence, or history of violating the court order. At this time, I do not have much confidence she would be able to follow an order of keeping her fiance out of the physical visits here in California. She did disclose to me that during the month of March, after her baby shower, she was unable to find time to contact the minor because her fiance and his family were always around. I'm going to read that again. She did disclose to me that during the month of March, after her baby shower, she was unable to find any time to contact the minor because her fiance and his family was always around. Mind you guys, her FaceTime visits are 10 minutes. Not 10 minutes once in March. Okay. She said she couldn't find any time to make that phone call and keep in touch with him. So given the hope and belief in a week-long period of minor being here in Los Angeles with her live-in fiance would be present for those visits. So the recommendation for father to maintain legal custody is partially because of the Family Code 3044, but it's also largely due to the ongoing concerns about mother continuing to engage in acts of domestic violence, her minimization of these acts, and the concerns shared by the school about mother's behaviors when she spoke to them, as it could have resulted in the minor being expelled from the program. I am, however, recommending that mother be granted access to the school's parenting application so that she can also be aware of the academic concerns, overall progress of the minor. Now, in speaking to mother about her perspective about the court orders and the allegations to the ongoing domestic violence perpetrated by her, she also seemed to minimize these different situations. For example, she described father being too strict with her and not being able to and not want being open to her exercising time for her December visit. In talking about the allegations of abuse, she continued to deny that this even God, I cannot. This is so frustrating. She continued to deny this, even though it has been documented as a finding by the court. Mother does seem to lack perspective on how and why these behaviors can be problematic and detrimental to her end goal of having parenting time with W here in California. Mother often refers to having, quote, served the consequences, end quote, for her actions by having been placed on professionally monitored visits, by having her visits limited to the state of Texas, and by having to take multiple parenting classes. However, Mother's historical violations of the court's orders indicate that she does not fully understand why her actions have been problematic and resulted in these various consequences. I'm also recommending that both parents enroll in individual therapy. They both have a lot going on, and they can use this to address the parental conflicts and the challenges that have resulted from such. From the time that I did spend with the father, he had a lot of emotions, and it would be beneficial for him to have a place where he can talk about them. Mother can also benefit from learning more about age-appropriate parenting, effective co-parenting, and possibly reflect on the different situations and concerns that have been brought before the court. But therapy should include discussions about domestic violence. And lastly, because they are younger parents, I am recommending that they enroll in a program, Young Parents Bright Future. This is a short online program designed to help younger parents navigate the court website. And that, Your Honor, concludes my testimony. You're up, Bailey.
There we are. Sorry. I know. I was trying to find it.
No, you're good.
And then the judge. Wonderful. Well, that was my I'm assuming, thought. I have some questions, and then both parties are going to want to ask you some questions. So I'm going to start. In your discussions with the school, and I won't name the school, well, let me back up. Are you an LMFT? Is that correct?
Yes, I am, Your Honor.
Okay. And what experience do you have in sort of early child behavior, development, and things like that?
Well, I worked as a therapist with children and families, particularly with children, for about 5 years. I worked in a RAD Brown program. I also worked in an outpatient treatment program. I served as a supervisor for a children's FFP program, so I've done the work.
That's a full service partnership, right? FFP?
Yes, FFP is full service partnership. Yes, correct, Your Honor.
Any specific training, exposure to your experience with children who might either be neurodivergent or ever have speech delays?
No, I did not. My focus was not on working with children with that were specifically neurodivergent. I did have some experience working with children, but it wasn't the main focus of the treatment that I was providing. Typically, we would refer out or connect through other resources.
I understand that W was not his full self, wasn't feeling 100%. When you were with him, did you hear him say a few words? Did you have the opportunity to hear him speak at all?
I did not. He also cried, but I did not hear him speak.
When you spoke to the school, you spoke to the director of the school, correct?
Correct, I did, correct.
And she indicated that she has specific experience in child development and issues such as that, correct?
Yes, that is correct.
And she did not independently observe any concerns in terms of W's speech or otherwise his development, correct?
Yes, that is correct.
Did she indicate that if she had, she would have informed at least the father?
She didn't say that specifically. She did say that when father asked, they talked about it, but she didn't say, I'm assuming that in that conversation she would have said something if that was an issue.
And your understanding is that the father specifically asked her something along the lines of whether she had observed any concerns regarding W, correct?
Yes, correct. Concerns about speech is what she said.
Okay, the arrest. I don't know if you were able to see it. The arrest was in Catalina involving Santos. Were you able to find out what the arrest is for?
Yes, Your Honor. I believe the Cletus, I believe the Cletus report. That's the system, the CLETS. That it was labeled battery spousal. It was all short, and it looked like battery spousal. Can I pull it up?
Yes, I recognize it's hearsay, and I recognize that there's a number in front of it.
Sure. 243E.
That's battery without injury of a romantic person.
And then there's a number 1.PC battery spousal.
And the date you said is?
The date is June 13th, 2025.
And when you say you felt that either he, I'm not sure if it's he or Miss Olson, was less than forthright about it, what specifically did you ask him or her and they denied it, or what led to that conclusion?
When I spoke to Mr. Salazar, I asked him if there had been any prior arrests. I specifically asked about anything since he and Mother had been dating. He said there haven't. And then I asked him if he recalled anything happening this past summer, and he said he did not. That was as much as he told me.
Okay, so you understand, I'm sure you saw the records, you found there was a domestic violence restraining order issued. I think you also probably saw, I'm pretty sure of this, and the attorneys will correct me if I'm wrong, that W was not listed as a protected party on the DVRO, correct?
Yes, I did, correct.
And we can talk about the reasons. It's not really relevant as to whether or not the court ordered supervised visitation with Miss Olson in Texas after that was issued, but you did not recommend supervised visitation between Miss Olson and W. And the reason for that is?
Well, I didn't come across any information right now that indicates that it's a safety concern for her to spend time with him alone. I understood when I spoke with the father that part of his concern was Mother not having had any recent visits with W. But when I observed her with W, he took very well to her. So I don't really have a reason to believe that he would be uncomfortable around her if they were not. Wait, hold on. Sorry, where's divisions? Around her if they were not, or if a third party wouldn't be present.
And your main, and so then your main, the justification for your recommendation that the visits, at least for now, with W be in Texas is because of the inability to control Santos, the inability to prevent Santos from being around, as well as at least a past, I wouldn't call it a pattern, but indication that Miss Olson has created by not complying with the court orders, correct?
That is correct. So again, choosing a man over her child. Okay, go ahead. Sorry. Sorry, Your Honor. Didn't mean to cut in.
And I think I have one or two more, and then I'll let you guys talk to her. Any concerns about parental grandmother and her watching W? Any concerns in that regard?
No, none were brought to my attention, and I did not pick up on anything during the process.
Did maternal grandmother indicate, did she have any other grandchildren, or is W her first?
She mentioned having other grandchildren and being heavily involved in their lives.
I know that you didn't have very much time with her, and she indicated, I think she said the last time she saw W was Mother's Day of 2025. Is that correct?
Yes, that is correct, Your Honor.
Okay. And then if I can confirm, the last time she and Miss Olson saw each other in person, was it January 2026 or
I don't know. I don't have a date for that, Your Honor.
okay, that's fine. Did she indicate that when Miss Olson goes to Texas, she visits her or spends time with her? Because I understand there was a visit by Miss Olson in Texas in November and December. Did she indicate, did she give any information that Miss Olson had visited her during those times in Texas?
I did not specifically ask her when was the last time or if Miss Olson has visited her in Texas. She did tell me that she had visited Mother in Texas when she had supervised visits with W.
Able or unable?
She was able.
Able.
Yeah, the Mother's Day visit last year, but as far as Miss Olson taking W to her, I don't have any answer for you, Your Honor.
So, in light of what you said, you know, the court's finding of DV by Miss Olson towards Santos and the reference to the arrest of Santos, I'm just curious. There was no recommendation that Miss Olson take domestic violence classes on top of individual therapy. Any reason that wasn't part of your recommendation?
Well, I am representing that discussion about domestic violence be incorporated into her therapy. I would leave it up to the court if they feel that that's something like a dual course would be necessary.
No concerns or indications in your review of any concerns of rug or can I say that
Alcohol
word?
abuse. I think we can say
Okay.
alcohol abuse, I think.
Alcohol abuse to the point where it's a problem on either side?
Well, I did assess for that. Both parties say they engage in social drinking. I would like to point out that the arrest in Catalina Island, Mother did say that her fiance was arrested for underage drinking. He was heavily intoxicated. He wanted to go dive off a cliff in a golf cart, and that's how police got involved. So there is a bit of a concern in terms of how much they could be consuming, but no one really gave me much more information than that.
I think that is all of my questions. My sense is once the parties ask you questions, oh, okay. So your recommendation regarding the school is that she have access to the parenting app, which allows her updates and information. Regarding legal custody, I will note that you recommend. It looks like sole legal, not tie breaking, but sole legal, correct?
Yes, that is correct, Your Honor.
And the basis for that is
Well, the basis for that is, again, the recent findings of domestic violence made by the court is due to when I spoke to the mother. There is a lot of minimization about historical issues of domestic violence. And then also the conversation that I had with the school about mother's behavior and how that could have resulted in the minor being expelled from their policy or in being expelled due to their policy.
And what about just in terms of everything you heard regarding the concerns that Miss Olson raised regarding her belief that there may be delays on W's part, that her participation with the doctor, the recommendation by the doctor, and Mr. Giesi's recounting of the follow-up. Any concerns in that regard in terms of how Mr. Giesi may or may not have handled it?
Well, I wasn't able to speak to a provider. Well, I wasn't able to speak to a provider on the other end that would have maybe provided some more clarity about what happened with that. in speaking with the father and in speaking with the school, it does seem that he didn't think about her concerns, but I can't speak to how far the concern was taken. But there is an indication that the concern was not ignored, but she was asking for the school about their thoughts on it. So he said he spoke with them, but I don't have any more proof of that other than him just asking about that.
Would your recommendation was there a way to craft a recommendation assuming that, let's say Miss Olson during one of her visits to Texas, or if eventually in California, decides on her own to take W to get, for lack of better term, separate second opinion, or do the referral herself? I think part of the difficulty, at least from what I read, is that it all sort of done online on the phone. She wasn't, at least according to her, in a position to fly out there and address it herself. Any Would this recommendation prevent her from doing it on her own, or would I have to craft something? And could I, let me ask you this. What if the court, I'm not saying I am, I'm not saying I'm not. What do you think of a possibility where this don't touch the legal custody at all, but allow Miss Olson at this time to take W in person to see a doctor to at least alleviate those concerns or address those concerns, confirm them, anything like that? What do you think about that?
I think if the court is inclined to make such a recommendation, it would be fine. I think the more clear of an order that's done, the more beneficial for the parties to avoid any possible issues in the future.
Yes, and I was not very clear on that question. Okay, I think that's all I have. I'm going to let Miss Budnick go first and then Miss Fonseca. When do you think you're going to need a break? Then Bree's attorney, can the pregnant lady have a break? She has to. Then the judge, why don't we, thank you. Let's just take a break then. For everybody until 5 of, does that work for you, Miss F?
Sure. So we're coming back at
Then the judge, 2:55.
2:55. Okay.
And then the judge, okay.
Thank you. Okay, so turn the comments back on. Since they're taking a break, we'll take a quick conversation break and then we'll dive right back in. I want to hear your guys' thoughts and opinions on everything we've seen thus far. Let me know what you guys think. What are your thoughts? Do you think that yes, you guys, these are the court, for those of you guys that came in late, these are the court transcripts from 429. This is the parental evaluator who I'm reading. This is her reviews. This is what got them their current plan going up until August. Lies she's cooked. Yes, I'll be posting all of this on YT. We can't say the judge sucks just yet because the judge hasn't made any orders. That's everything I'm reading. Typically, I'm the judge, but everything I'm reading is the parental evaluator. Yeah, I think that you guys, I hold on. Do we have a queen in the building? Was that Queen Junkie? Thank you, Queen, for being here. Hi, love. I love me some tea junkie. It went by so fast though. My YT, you guys, is the same name. As here. It's also linked in my bio, but it's Angie W1470. It takes hours to download. I will download it tonight and then I will post it on my YT. It'll be up in the morning time. Tea Junkie! Love you, girl. Am I surprised? No. Clearly Brian Santos didn't come up with a story. Thank you guys much. Didn't come up with a story to tell the judge together, because what the hell? The fact that he just blatantly lied and then she pulls out the documentation to show that he lied is mad crazy. Yeah, listen, you guys know I love me some Tea Junkie. I've said always, I truly believe that. Listen, I love everybody on this app, right? Well, most people. I truly feel that Tea Junkie is bigger than this app. I think she's going to end up on TV somewhere. Like, yeah, love her. And if you guys did not see the last video that she posted, you have to go watch it. We showed it over here on my live yesterday too. It was amazing. Okay, did we get all the questions asked, all the good stuff? Oh, I got a pussy on my head. Thank you. Listen, Santo, she says Santo's probably kicking a cliff right now. The fact that he's lying so much blatantly, I think this was a question last time and I'm going to answer it. Could he get in trouble? Technically, he's not lying to a judge. Now, I don't know if he was sworn in under oath before speaking to the parental evaluator. I don't know. So if not, we're not. We probably won't. But it's definitely affecting her case. It's definitely affecting her getting to see her child for sure. It's definitely. The judge is actually more concerned with the reason, or not the judge, sorry, the parental evaluator is basically saying the mom has a bond with the child still. I wouldn't have a problem with the mom seeing the child, but I don't trust her to not have Santos around, and Santos is not allowed. I don't trust him. He lied to me multiple times. I don't trust him. So, yeah, he is the right. This is why he was breaking the car windows. Right. That's crazy. So, all right, here we go. So we'll end our break. We got to follow judge's order. She said 5 minutes. All right, we'll turn these back off and then we'll come back on. For those of you curious, we are on page 42. We're almost halfway done. This is actually going pretty smoothly. Okay.
I did want to say really quick that it does break my heart for W in the sense that his mom couldn't even find 10 minutes to step away to call him.
That's
like
crazy.
10 minutes.
Yeah. Wait, where's my notes? Hold on. Let me find the page. Oh,
I did that. I mean, I live with my child full time and I stepped away from work for 10 minutes today because my child called me.
Right.
Like,
It's crazy.
you just did it for your child.
Yeah. It just doesn't make any sense. We'll just turn that down. On my notes from what John stated is that in March she called a total of 25 minutes. 25 minutes is what he called, and that she was supposed to call 30 minutes a week. So whatever. Thank you for Bailey. Okay, you ready?
Thank you. Was that for me?
Yeah.
Thank
You get
you.
all sorts of gifts, girl.
I'm not even paying attention. Thank you,
deserve
guys.
it. Okay, ready?
Yep. Okay. Then the judge. Back on the record, we have Miss F. I think I was done. So, Miss Budnick, go ahead. Then John's attorney. Sure, just a couple of questions. When you observed Miss Olson with the minor child on Tuesday, were you aware that prior to that interaction, Miss Olson and the minor child had not seen each other in person since December of 2025?
Yes, I was.
Okay, and based on your observation, these 4 months that the minor child went without seeing his mother in person, did that not appear to affect the minor child's attachment to mom or recognition of mother, correct?
That is correct, yes.
And your recommendations are not to impose any supervised visitation requirement on mother at this time, correct?
That is also correct, yes.
You also testified or noted some concerns with violations of court orders by mother. Is there a point at which the violations would rise to the level, in your professional recommendation, of warranting a supervised visitation agreement?
Hypothetically speaking, given the dynamics in this case, if there continue to be issues with violations of court order, particularly if the orders are being put in place for the mother's best interest, then possibly, yeah. I think possibly exploring that avenue again might be an option. That's what comes to my mind right now.
Okay. One of the recommendations you made was an allowance for the respondent to travel when she exercises visits in Texas, to travel to surrounding counties of Dallas or even to Corpus Christi, Texas, correct?
Yes, correct.
What safeguards would you recommend to ensure the mother does not remove the minor child from any of those counties without telling father? You know, like has occurred in the past.
Well, I mean, the biggest safeguard, biggest safeguard is everything that's in whenever the court decides to recommend, or sorry, whatever the court decides to recommend in terms of the limitations of the county, I did provide a recommendation about mother letting father know where the minor child will be, staying with her when it's her parenting time. As far as anything additionally, I believe hopefully would be it would just come down to mother being forthcoming and following orders. Love, she doesn't. She doesn't do that, ma'am. Not Miss F. Wake up. She doesn't. She told you she doesn't. You even admitted she breaks all of them. But anyways, sorry. Go ahead. I'm back in character now. Go.
You are aware of the distance between Corpus Christi, Texas and Dallas, Texas.
I believe both parents told me it was about like a 2-hour flight.
What recommendations do you have if, hypothetically, mother were to fly with the minor child to Corpus Christi? What safeguard would you recommend to ensure she didn't just get on a flight to go to Los Angeles, for example?
Well, like how to protect and make sure that the mother is following court orders
Exactly.
and not. I don't think I have an answer for you off the top of my head. I think I would defer back to the court and see how the court would want to handle something like that if mother were to violate the order again.
And can you just let me know, if you know, what specific family connections or support does mother have in Corpus Christi, Texas?
She mentioned her mother, but I don't know about any other specific family, but she did mention her mother.
And just, I guess to remind me, the mother's maternal grandmother's testimony was that she hasn't seen the minor child since May of 2025,
That is
correct?
correct. That is correct.
Okay, I have nothing further, Your Honor. Then the judge. All right, Miss Fonseca, then Bree's attorney. Did maternal grandmother Brianna's mother mention being pregnant at the Thanksgiving 2025 visit in Dallas with the other relatives?
No, no, nothing specifically said that the last time she recalled seeing him was Mother's Day 2025 for a visit.
When you said that Dad had reported the relationship ended before, I guess before they found out that she was pregnant, did Dad mention why he wanted no part of the pregnancy?
I'm not going to quote him. I remember him saying that there was drama, is I think what he said, and that Mother had been making different allegations on the internet, and he wanted to distance himself from that, is what I remember him saying. But he didn't give me more information other than that.
Did he describe when or how they reconciled before W was actually born?
He described a time where they met in Florida, I believe, where he said was the last time. Wait, I lost my place. Sorry. Let me go. Sorry. He described a time where they met in Florida, I believe. Where he said was the time that she became pregnant. I believe was in like September of 2023, but he did not describe it to me as a reconciliation. He said it was mother had wanted to get closure.
So, maybe a better question, because I know you mentioned speaking to maternal grandmother about her being at the birth and talking to Dad at the birth. So, to your knowledge, was Dad present at the birth, correct?
Yes, that is correct.
So, as a follow up question to the one I just asked, did he describe to you how he became to be at the birth if they had this falling out at the beginning of the pregnancy and he wasn't involved?
Sorry. He did talk about them touching base before the birth, but I don't recall exactly how that transpired. I don't think he spent too much time talking about that, but there was communication between them before W was born, is my understanding.
And did you discuss at all him serving Mom with the case the same week that she gave birth to W?
He mentioned that to me. I believe he said he lawyered up was the term that he used shortly after W was born. I think, if I recall correctly, he said that he had gone after W was born to Mother's home with Mother. He was trying to help her reorganize items. Mother became upset and they had an argument. And then she said, "We don't need you here." Something along those lines, meaning W and Mother. That's what I recall from our conversation yesterday.
Regarding the history of residences, did Dad disclose anything about the apartment he lived in during the pendency of this case? Then John's attorney, that's. Then the judge, hold on, what's your objection? Then John's attorney, it assumes facts that have never been put into evidence. Then the judge, well, not by this witness. All I heard her testify is that Dad lived in a 5-bedroom home in Texas, and previous to that he lived in another, then John's attorney, another house in Texas. Then Bree's attorney, I'll rephrase. Then the court, yes. Then Bree's attorney, did Dad disclose ever living separately of his mother during the pendency of this case in an apartment?
He told me he had an apartment. I believe he said it was in Tampa, but he said that since receiving custody, he said that after W was born, he came to Los Angeles, and then after he received custody, he moved back with his mother in Texas. Sorry. He didn't talk too much about how long or how much he was spending. He was spending in the other apartment in Tampa.
Nothing about any apartment locally in Texas, local to his mother?
No,
Did he disclose anything about a business partner living with him, his mother, and W during the year of 2025?
no, we didn't. When we talked about who lived in the home, he only mentioned Mother and W. Sorry, guys. Past my bedtime. We did not talk about any other people that could have lived with him in the past aside from his sister and her fiance. Excuse me, her husband, who has since moved out. He said,
Regarding their relationship that he said he was with 2 members of Mother's family, a cousin and an aunt who lived in Texas, did you explore from his perspective if Brianna had a relationship with those same 2 relatives of hers?
he didn't talk too much about Mother's relationship with them or what the relationship was like. He did say that Mother that Brianna is not aware of that relationship, but I don't know what type of relationship Brianna has with the cousin and the aunt.
Meaning that Brianna was not aware that John had this relationship with her blood aunt and cousin, correct?
That is correct. That is how I understood it.
And did you review the text messages that opposing counsel submitted yesterday morning for purposes of the PPA between the maternal aunt and Dad?
I did not.
So did Dad at all disclose using the maternal aunt to, for lack of a better term, secretly supervise Brianna's time with W in November of 2025 and report back to him during this visitation? Then John's attorney, objection, argumentative, compound. Then the judge, okay, let's break that down. Did Dad, wait, did you talked to this aunt and the cousin, correct?
I did not.
And then the judge, oh, you did not. Okay. Did Dad indicate that they were involved in any way in Brianna's supervised visitations in Texas?
No, he did not.
Then John's attorney, and you said you didn't review the texts that Dad submitted, correct?
I did not. Correct.
And would it be, I guess, in your years of experience in doing these sorts of evaluations, Would it be unusual if a parent secretly employed a relative of the other parent to observe visitations? Then John's attorney, objection, evidence code 352. It assumes facts not in evidence. It calls for speculation. It's an improper hypothetical. Then Bree's attorney, this is their evidence they supported before the PPA. Then the judge, no. There's an objection pending. And the way courtrooms work is when an attorney makes an objection, a legal valid objection, the court will hear from you if you have a response to a legally valid objection. A legally valid objection is an improper hypothetical, assumes facts not in evidence, compound, are all valid. Just because somebody gave somebody something doesn't lead to an appropriately phrased question. So it is a weird hypothetical. It assumes facts not in evidence because specifically she said, I didn't review the texts. And she said, Mr. Giese did not say anything to me about the family's involvement at all. So when you have a hypothetical, you have to have some basis in fact that have not been introduced in any basis in fact before that. So that is an improper hypothetical, and that is improper evidence. Then Bree's attorney, so are we allowed to introduce opposing counsel's evidence to ask the witness questions about it, since she said she did not have a chance to review it? It was submitted yesterday morning as part of their PPA letter. Then the judge, okay, are you able? I hate to make you log out because then you have to. Are you able to put yourself on mute or turn your microphone? How do we do this? I don't want you to hear necessarily what we're hearing. Michael, is it okay? Michael is going to figure it out. Can you hear me? Okay.
You guys are muted, Your Honor. I can't hear you, so I'll just wait.
Then the judge, okay, she can't hear. Okay, so let me see the text messages first, because it's hard to ask somebody something about something they didn't see, and then to say, is it weird? I mean,
Do you want
then
me to
John's
do you want me to do
attorney,
the attorneys now so you're not reading all of them?
sure.
Until she comes back in. Okay, so John's attorney. I don't actually have copies of them with me because I wasn't.
I bet Miss Fonseca does.
Miss Fonseca? Yes. Taylor's John's attorney. And just so the court is aware, these are messages my client received from an aunt of respondent.
I get it.
Miss Fonseca saying that visit.
Let's do this. The court is very good at unringing the bell. Let Miss Fonseca show them. Then I'll hear from both of you, and then the court will decide the impact, the relevance, all sorts of things. Let me ask you this. Is it your position, Miss Fonseca, that the aunt and cousin were involved in Miss Olson, and Miss Olson did not know?
Bree's attorney. Oh, that's exactly the situation.
And how is it? They just surprised and showed up?
Bree's attorney. No, they were part of an outing with the family, and John had previously engaged the aunt, I guess, as a spy, for lack of a better term, and was texting during the visit with the aunt who was present at the visit.
Okay, hold on.
And testified about.
Hold on. Hold on. So it's Miss Olson's visit.
Bree's attorney. Yes, with an aunt that she does not have a relationship with, but her mom was there in town, so her mom invited her own sister, the aunt, to this family outing.
So it was presented to me initially that somehow or other Mr. Giese got these people to like hide in the bushes. So Miss Olson
No. So that's not
didn't
Miss. Yeah, Miss Budnick is no, sorry.
Didn't know.
Miss Reed's attorney, they didn't know she was communicating at all.
Okay, let's watch the language and the smiles. It's undisputed that Miss Olson knew the mom and her mom and her aunt were present, correct?
Miss Fonseca, correct.
What she didn't know is that her aunt was communicating with Mr. Giese.
Miss Fonseca, in real time, correct.
Okay, let me throw this out. Let's say, for argument's sake, that's true. And so your point is what? Because I'm going to be honest with you. I don't see the problem with that.
I mean, with a parent with a parent, with a parent employing a relative behind the other parent's back to, I don't know how to say it without saying spy, to watch without their knowledge.
Well, hold on. Miss Olson knows she's there.
Right?
So is it that Miss Olson doesn't know the aunt is communicating with Mr. Giese?
At his direction, correct. She always has to throw something in.
Okay, at his direction. Again, I'll be frank. I'm not seeing the problem with this. I'll tell you why. This occurred after the March incident with the cops and that. You can show it, but I don't think it has the same effect. This is after, respectfully, the evidence I've heard so far that she lied to Mr. Giese about where W was. And I think what I heard from the evidence, she may or may not have completely told the truth about whether her mom was there at Thanksgiving, because if I recall the evidence, Miss Olson said, "Oh, at Thanksgiving, my mom was there." And hold on, Miss F said she didn't. I understand that. But with all of that, look, after somebody has taken a kid from Texas and not returned him, and he had another set of eyes on her, I got to be frank. I don't see a problem with that. So you can show it, but I'm not sure what the relevance is, because I think I think at that time it wasn't professionally monitored, right?
No.
Okay, well,
We're month 3 of non professional visitation.
some people may have said, and it's been said in this court, I don't take it personally. I don't want to say accused, because some people have mentioned that this court was too lenient on Miss Olson after they claim kidnapping their child, and despite all of that, allowing non-professionally monitored I don't even think I said any supervised.
Hi, Judge Bershon, if you're watching. Wait, how would she get that information?
I
That's
don't
what we
know.
talk about over here, is how we feel like that not just me, but like over here on TikTok is what I'm saying. That where the judge is too lenient because of the whole kidnapping thing. Now, of course, I say that I grasp because she was not served correctly, because I know how the law is with, getting served. She should have been served properly, but that wasn't the judge's error, that was Taylor's error. But anyways, hi, Your Honor, if you're watching, we love you over here.
She's on the TikTok streets.
Right. Thank you, love. Okay, sorry. Then I have to answer Ms. Taylor, John's thing, no supervision.
No supervision. In light of that, the fact that the relative that she knew she was there might have been communicating with Mr. Giese, maybe even at Mr. Giese's direction. Again, I'm having a problem with the problem with that, the impact. I know she didn't like it. I know she thought it was a little sneaky, but I can't say it's not an extra safeguard, actually. She already had indicated to him she's not going to be honest about where she is. She's either flown or driven a couple hundred miles from Dallas to San Antonio. She's taken the child from Dallas to California. I'm not sure I necessarily have a problem with that, unless I'm missing something.
Bree's attorney. We'll just have to agree to disagree because I thought that was jarring. But if the court does not agree and thinks that's a waste of time, then I'm just certainly not going to waste your time showing those text messages. I can move on.
I appreciate that. Thank you. Okay, Michael, we can unmute her. Miss F, can you hear us? Then the clerk, she has stepped away. Then the judge, well, while we're doing that, Mr. Giese was communicating with Miss Olson's aunt, and either at his direction he's saying, will you watch out for W for me and report back? Is that what the offer of proof is?
Bree's attorney. And would he testify? Yeah.
The client wants to say something. Does your client want to say something? Discussion off the record between counsel and client.
Ms. Fonseca, can I ask for? There are two more suggestions for strikes because this is not public knowledge. The mention of her new home, where that town is, it's not public knowledge, and the mentions of where her new apartment is also not public knowledge.
Okay, I have to tread lightly because there have been no requests under California Rule of Court 2. It is 2.551 to seal or close anything like that. And this is a matter of public interest for some reason. I have no disrespect for you all. I don't know why, but a million people were logging on left and right. They have been in the courtroom. The court would have had absolutely no power to kick them off. So where it comes to W, I think the court can push the limit in terms of where his school is. Things regarding his medical condition, things covered by HIPAA. But absent a rule of court 2.551, motion or request to seal, and things like that, this is where the First Amendment, and we talked about it, is at its height. And so while I'm willing to strike the school, I mean the court has to tread carefully with that because you're really striking something that's already in the record. Anything beyond that is after the fact. I'm not comfortable doing that. And it doesn't matter whether you two both agree because there's another party involved. There's the public. There's the fourth estate. There's the media who seems to have an interest, an intense curiosity for some reason about this case. Okay, is she going to keep talking while I'm talking? Okay, all right.
Sorry. No, this is the evaluator back. And that whole is she going to keep talking while he's talking was about Bree. She can request to come up, or she can. It says the witness. So I'm assuming that's the evaluator. Oh, she can't request to come in because it's locked.
The judge. Okay, all right. My clerk will handle it. But it's interesting because everybody is concerned about people's privacy, and yet they're willing to talk about people's medical records in open court. They're willing to file a public motion and talk about concerns that W might have something or not. I'm not even going to say the word because I think it's going to get repeated. So we have to decide what our approach is because one day we're concerned about the First Amendment and the open court, and the other days we're not. So there's got to be some guiding principles for this court. So respectfully, I'm going to deny that request. I'll only strike it as it relates to W's school because it involves W. Anything else, I will ask her when she comes back not to say anything regarding where people live. But once it's out in the record, I'm not going to strike it because then I'm concerned about prior restrictions and I get sued for that, which I'm fine with. I'm just trying to avoid it, okay? Any other concerns?
Taylor, John's attorney. No, I just checked. My client, the fact that he resides in Texas is already in, like, I don't know. Or I don't have. There is no reason to strike that. I think it would be a waste of time.
You guys put your lives out there in the media. I didn't do this. You did this. So people, they are very curious about you.
John, yes, ma'am.
They are going to find out where you live and find out what you do. And that's always been this court's concern about the amount of information regard you two have chosen to put your lives out there in the public. W has not. That's why the court is so concerned about decisions we make about what we say about W in open court.
Bree, well, what do... And then John, so am I. Miss Fonseca, Bree's attorney. I could send her an email because we know.
Yeah, that would be great.
Bree's attorney. Oh, she's back.
Can you hear us?
Hi, yes, I can hear you.
Yes, we can't see you. There we are.
Sorry about that. The power dropped off in my block and I just had and it just had happened now. So I'm back.
Miss Fonseca, next question. Then Bree's attorney, when you were asking Dad about substance abuse and cigarettes, and you said he admitted to smoking cigarettes, was that inside or outside of the home? Meaning where he smoked? Or did you not ask him that?
I didn't specifically ask if he was inside or out of the home, outside of the home.
Did you ask him or Grandma if Grandma smoked cigarettes?
I don't think I asked Grandma. I don't recall asking Grandma.
Regarding the concerns that you shared that Dad had shared about Mom not being truthful about W's location during her parenting time, excuse me, did Dad specifically if his did Dad specify if his concerns as to location was about where W was staying overnight or more so about the play-by-play of where W was throughout the day with Mom?
I understood it to be with overnight, but I didn't specifically ask him the question in that way. I didn't specifically ask him if it was a play by play or overnight. I understood it to be overnight.
You said that Dad noted concerns regarding Mom's fiance using rugs. Did you explore that at all with Dad? Meaning, did you determine and ask him questions to figure out why he thought that?
I believe he said because of videos that he had, but that was as much as I got that I remember off the top of my head.
If you know, was it social media clips from third parties or videos that he personally had of Santos using rugs?
Oh, I don't know. He just kept referring to his phone and videos, and I let him know that I can't view anything that both parties are not providing me with. So we have a hard time viewing videos here at court. So
And regarding Mom's legal custody concerns, did you dive into that as far as what specific concerns were, or was it just more generalized where she responded she felt being left out of everything regarding big decisions for W?
I understood it to be feeling left out of bigger decisions, not having access to the medical application, which she said I believe she said she had to fight for that, and she now has access. Not having access to the school parenting app, and then she also mentioned feeling as though she was heard doing or during the January appointment when she brought her concerns to the doctor because prior to that I understood it to be that she did not feel heard.
And did you get the read from any of Dad's responses throughout the day that he understood that there has been a standing order for Mom to have access to W's records? Did you either ask him about that directly or just get that general sense from any of his other responses?
Hold please, I backed myself out. Hold on. Okay, can you tell me what line we're on?
We're on page 60 and it is line 4.
Hold on, thank you. I
You're
put in
welcome.
58. Okay. Can you please repeat the question? I'm sorry, it cut out. Oh my god, both hers and I's cut out at the same time. That's crazy. It literally says, "Can you please repeat the question?" I'm sorry, it cut out a little bit. It's funny.
As far as Mom's continued right to access W's records, did you understand from any of Dad's responses that he understands the order to be that way, or did you ask Dad any questions about that particular order?
Oh, yes, we talked about it. He said, so as far as the access to the application and not granting mom not having access to it, he said that mother was asking for his login, and he was not able to provide her with that. That's why that's the way he explained it to me with respect to that. Are you referring to anything else that she doesn't have access to?
Well, I'll ask a follow-up question on that response, actually. Did he ever tell you the school was the one that denied Mom access to the Parents app?
I don't recall him saying that specifically. I recall him saying that mother wanted access to his login. I don't recall him saying that to me. I recall the school saying they had to go through school.
And when Dad said that Mom was allegedly asking for his login and he told her he couldn't provide that, did you see in our Family Wizard thread or communication that proved that was truthful?
I didn't have time to review all of the communication in our Family Wizard, so I didn't read anything along those lines.
And on the same topic with our Family Wizard and medical records, did you have a chance to cross-check the medical appointments reflected in the records and the Our Family Wizard communication to see how many times Dad did or did not tell Mom about appointments for W?
I did not. I did have a chance to look at the aftercare summary that was provided as far as the file, and I think I recall, if I'm recalling correctly, that on each summary there was a follow-up information about follow-up dates, but I do not recall seeing anything specific about their communication on our Family Wizard about it.
And did you talk to Mom about the January 6th hearing when the judge made the order for the visitations to stay in Texas at that time? Did Mom explain to you that she had shared she would not be traveling due to her pregnancy?
She did, yes.
And so, kind of segueing into your recommendation yesterday, when she came to your office, you visibly recognized that she was very much pregnant, correct?
Yes, that is correct.
And did you discuss when her due date was with her?
She told me it is in July.
And did you ask her if she had any intentions to travel from California to Texas this late in her pregnancy before she hits her due date in July?
I did not. She herself told me that she has a high risk pregnancy, and that she was advised not to travel. She said she learned about this in January.
And with that in mind, how would you expect her to travel to Texas, very pregnant and giving birth in July? Was it your recommendation she just do it anyway?
Well, when she said that to me, I did ask her if she could send me something from her doctor indicating that this is what's being recommended, because I don't have anything. I didn't come across anything in the file for that. She said that she would look for something, but I did not receive anything. And I don't have any information from a doctor supporting this medical information. Okay, can we take a quick break right there and
Clock
turn the
it.
comments back on? Because I actually want to take a quick little break, but I want to talk about this. Um, because again, Miss Fonseca, Bree's attorney, is still trying to hammer home, but now it's this late into the pregnancy for traveling. She hasn't traveled since the day she found out she was pregnant. And she says, Miss Fonseca even says in here, well, it was since January. Okay, so January, February, March, April, May, June, July. That's 7 months left. So less than 2 months pregnant, she found out she was high risk. High risk how? Remember, she said she was high risk 30 seconds after pissing on the pregnancy test. She was high risk. Later came out and said that she was constipated, so she was full of shit, which correlates with the hemorrhoids that she now has because she's a pain in everybody's ass. So all of that makes sense. That does not partake to a high-risk pregnancy. Right, let's not even talk about the travel to Paris. How long is that flight? So you can travel to Paris. But you can't travel to Texas to see your child. If you wanted to, you would. She doesn't want to, so she can't. Right? She's never been high risk. And if she was, and I'm so glad, because a lot of you guys asked me this I'm so glad we got these transcripts. A lot of you guys asked me this before. You said, is the court, or does she have to provide medical documentation to the court? No, technically she doesn't, because the court can only say you can have this visitation with your child. They can't force you to see your child. So she's saying that she's like, hey, listen, you don't want to see your kid, you don't want to see your kid, right? But the evaluator asked her for it. Bree says, oh, I'll look through something. Mind you, she was actively pregnant, going to the doctor on a more regular basis. As she got higher up, she could have got something. And she chose not to, because she couldn't. My opinion. So, all right, I'm gonna take a quick bathroom break. Bailey, will you guys in the comments can chat for a few minutes? Bailey, if you want to take a break too, or go about whatever, or just keep talking, and then we'll come back in, and then we will finish it up. We got about 39 pages left to go, and I'm staying on until it's done. Okay, so I'm gonna take a quick bathroom break.
She did say in December that that was her last visit in Texas. I vividly remember that she was like, I am not going back to Texas. This will be my last visit. Nope, she has no documentation because, I mean, in my personal opinion, you can't take a constipated letter and be like, I'm high risk because I'm constipated. Her words. I could not imagine choosing a man over my child. Like, that just blows my mind.
Oh, about her choosing Santos over W?
Yep.
Yeah, lying to that's the whole thing is blowing my mind. Listen, this is why, though, why it is important for us to get the transcripts and put this stuff out, because if not, it's literally just John's word against Bree's word. You know what I'm saying? And so it's a blessing that Sock Gang paid for this one. I paid for the next one, and we're gonna get all the direct information so she can no longer lie about it. Okay, are we ready to keep on?
Yes, ma'am.
Okay. Okay, so I'm gonna reread that my answer again. I did not. She herself told me that she was a high risk pregnancy and that she was advised not to travel. She said she learned about that in January. Thank you.
And with that in mind, how would you expect her to travel to Texas, very pregnant and giving birth in July? What is your recommendation? She just do it anyway?
Well, when she said that to me, I did ask her if she could send me something from the doctor indicating that this is what's being recommended, because I don't have anything. I didn't come across anything in the file for that. She said that she would look for something, but I did not receive anything. And so I don't have any information from a doctor supporting this medical info.
Do you have any medical training or background regarding the safety of traveling on an airplane when you are at the end of your last trimester of pregnancy? Then the judge, I think no one knows the answer to that. That's an argumentative question. Then Bree's attorney, regarding the birth of the newborn, and again, in the context of your recommendation to the visits to remain in Texas, was it your, I guess, future view that she would be traveling immediately with a newborn to make sure she makes these visits with W since she'll be breastfeeding? Then the judge, hold on. Whoa, 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 whoa. Okay. Traveling immediately with W because she'll be breastfeeding? There's a lot of no disrespect. I think it's everybody's goal to breastfeed. I don't know if she breastfed Winner or not, or sorry, W or not, but did she breastfeed W?
Ms. Fonseca, briefly, yes.
Then the judge, well, I don't want to get into it, but it's no disrespect, not making judgment about breastfeeding. Not all moms breastfeed right away, or maybe they can't when they don't. So there was a lot in there. Let's ask a not so compound question regarding traveling that doesn't assume that she's automatically going to be breastfeeding. Then Bree's attorney, so leaving breastfeeding out of it, with the recommendation in mind, after she gives birth in July, was it your future idea, in light of the traveling recommendations, that she would be traveling with a newborn to the visits with W?
I assume that when she felt comfortable to fly with the minor, when she felt comfortable enough to fly with a newborn, that she would possibly do so. But by far as how soon that would happen, I don't know. Let's not forget she wanted baby W to be doing that too at just a few months old. So
Yep. So between now and whenever that future date would be, if she can't travel or won't travel, then it was just the FaceTime recommendation is enough based on the relationship you observed between her and W to maintain their relationship? Then the judge, hold on. The FaceTime issue is enough to maintain their relationship? Then Bree's attorney, is it her view that the FaceTime order would be enough, based on their relationship she observed between Brianna and W, to keep that relationship established while they are physically apart? Then the judge, hold on. No one is going to talk under their breath. I know you both. It's still a courtroom.
John, yes, ma'am.
That's okay. Anytime there is an objection, the court has to rule on it. Okay? I think the facts kind of speak for themselves. I know you're going to argue that. Absolutely. And I will hear it. And there also has been testimony both of her and previously for a significant period of time your client chose not to. And I know she's going to saying it's because of her physical condition, but I know there was a period of time where she wasn't pregnant. And then there was the choice not to even have the FaceTime calls in March. So the way these questions are sounding is sort of saying by her recommendations, it's in essence going to somehow or another break the relationship between her and W. And I get that. But the flip side of that, there's also a history of her opting not to take advantage of those opportunities when she's had the opportunities. So I'm not sure that's necessarily a fair question to this witness, who is very qualified in a lot of ways. And she said, I observed their connection, but she's also indicating I'm not, a child development specialist. I can't say what their relationship is going to be. So I'm not sure that's a fair question. The facts are what the facts are. And I'm sure you're going to argue that this recommendation is going to make it difficult given her pregnancy to travel. I do have one question along the lines. Were you ever provided any kind of documentation regarding her limitations in her pregnancy?
I was not, Your Honor.
So there was no documentations about whether or not she could fly, or whether or not she could drive long distance, take a train, whether she was subject to bed rest, whether she couldn't, something. There was nothing along the lines of any kind of limitations.
Not with respect to documentation. Not that was shared with me.
Okay, next question.
Okay, hold on. Before
Then,
we go to the next question, I actually want to go back up and I wanted to highlight something real fast. I want to make sure nobody missed this part. Hold on, I gotta go up a couple pages. We make sure to tell me what page we're on when we come back in line.
okay.
Okay, so the question was, so between now and whenever the future date will be, she can't travel or won't because she hasn't, because she won't. Not that she can't, she chooses not to. And then it was just FaceTime recommendations. Mind you, if you guys remember when they came out of court, Bree went to them and said, Your Honor, I'm choosing not to take my visitation in California. I'll take a FaceTime visit. That's what she said back in whenever they went to court.
January.
In January, right. Mind you, she was like 10 minutes pregnant. Okay? So I just want to point that out. She says in here herself, she will not.
Yep.
Or won't. Okay, what page again now?
65, and I'm going to start on line 22.
Line 22. Okay, sorry.
You're good. And just so you know where I was going with that, in the pre-hearing meeting, we discussed extensively the bond that was observed. Then the judge, yeah. Then Bree's attorney, and counsel still asked repeated questions on the topic of potential reunification if there is a significant physical separation. And so I had asked the evaluator, well, how do you see this playing out given the situation? And she said, well, things could be very different in 6 months. And so I'm trying to establish for you, since you weren't part of that meeting, because I am anticipating that's going to be counsel's repeated argument, is that if my client doesn't physically go see W until after her newborn is here, then now all of a sudden we'll need some sort of litigation regarding reunification. So I'm just trying to establish the record from our evaluator as to her opinion of what the future would look like. Then the judge, I'm just not sure she's in a position to make that. I'll certainly let you argue it. I'm not really sure she's in a position. Here's what I will say that I heard. That it did not seem that W did not have any problem bonding with his mother, and he went right up to her, and she was able to comfort him. That's good. That's good to hear. Other than that, I'm not really sure what more we can take from that. The facts are that the facts are what they are not great. I get it. Next question by Miss Fonseca. Then Bree's attorney, yesterday when you mentioned that Grandma facilitated, I guess bringing in or taking out W during the observation period, was there a conversation between Grandma and Brianna that you observed about W being taken to the urgent care?
Yes, briefly. They discussed the plan to take him to urgent care. It was maybe they were in the minute. They were there for maybe a minute. It was not long.
And did Grandma tell Brianna that she would let Mother know would be where she was taking W?
I believe she did.
Go ahead.
No, I was just trying to recall. I believe she did, yeah.
By the end of your time with everyone yesterday, did you hear further if my client found out whether W was being taken?
No. When the shortly after I concluded my observation of the client with W, both parents left, and well, first father left with W and his mother, and then shortly after that, mother left as well. So I didn't hear anything more about the conversation about that.
When you interviewed Brianna's mother and she said that she did try to reach out to Dad at the end of last year about wanting to be a part of W's life, but Dad didn't respond, did you have a chance to ask Dad about that? I guess comment from Grandma to see why he didn't respond?
I first of all, let me just sorry, this is just me interjecting again. The fact is that the end of last year, the child would have been almost 2 years old, 4 months shy of 2 years old. That'd be a flood. And she's just reaching out for the first time now to see if you can see the child. No, where have you been this whole time? That would have been my answer, but sorry.
Yep.
Now I'm going back into the evaluator. I did not, because the conversation I had with Grandma was in the later part of the afternoon, and I had met with Father earlier in the day.
And you said that Dad, or that maternal grandmother, reported that Dad told her at the hospital when they were there for W's birth that he was going to serve Brianna with court papers? Then John's attorney, objection, it misstates the testimony. I also think evidence code 352, relevance. Then the judge, hold on. I'm going to allow looking at the relationship between the parties. And I think what Miss Fonseca is saying, she's pregnant. They're at the hospital, and his focus is on serving the papers as opposed to bringing a new baby in. Am I correct in that? Then John's attorney, yes. Then the court, go ahead, if she's able to answer the question.
Okay, can you please repeat it? My connection is not great, and I did not hear the question.
Then the judge, go ahead. Then Bree's attorney, when you interviewed Brianna's mother, she reported to you that while she was at the hospital with John and Brianna for W's birth, John discussed with her his intention or his plan to serve Brianna with court papers.
Yes, that is what she informed me on the phone, yes.
And did she seem bothered by that when she made that report to you?
No, judging by her tone and her voice, I wasn't looking at her. It doesn't appear to me that she sounded bothered. She was just providing me with the information. But I didn't ask her how she felt about it, so I can't really speak to how she felt.
Regarding the school, and again, did Dad ever say why? If he did say, strike that. Did Dad say that he did not want Mom to have access to the app for any reason?
I don't recall him saying he didn't want her to have access to the parenting app.
And other than,
He didn't want her to have his login, but not necessarily the app.
and when you said talking about the recommendation for both parties to enroll in individual therapy, you said Dad has a lot of emotions, so it would be good to give him some space to talk about that. Can you describe what you meant by that comment?
Sure. Well, he was very excited. He said himself, excited in a way to overcome with emotion. Not necessarily excited to be in the room with me. He himself said that he hadn't talked about this with anyone. He took a lot of deep breaths. His eyes were a little teary during certain moments when he was talking about the case. The impression that I got is that he's been bottling up a lot of this. And it would be good to have, man, it would be good to have space to talk about everything that's happening. So that's what I meant by a lot of emotions. It's a lot of, it change in his tone of voice, the expressions on his face, the comments that he was making about not talking about this with anyone, having to recall the details, and that was bringing up for him. Wow.
You know you're a good parent when, yeah, okay.
Yeah.
Then Marie's attorney, we're going to shift to some of the court's
Yeah, wait,
questions for you.
sorry. Brain strain. Don't talk about him being a great parent and getting emotional about that shit. No, fuck my last question. We're gonna shift away from that. New question. Strike.
Yep.
Where's my thing? Hold on. Where's my gavel? Jordan, where'd you put my gavel? Oh, here it is. Your Honor, strike the last question. We don't want that mushy stuff, him talking about being a great parent and how this all affects him emotionally. Order in the court. Jesus Christ. Sorry. Okay, focus. You're on.
We're going to shift to some of the court's questions for you. When she asked about the visitation being here versus in Texas, and you expressed, in your view, the issue here would be the enforceability, if you will, or keeping Santos away from the visit. Is that the sole or primary basis on which you're asking the court to keep the visits in Texas, or are there other reasons that you're making that recommendation?
That's not the sole reason. That's part of the reason. Typically, when we make recommendations in capacity of for children that are 2 years old, we don't typically recommend that they do so much flying back and forth. Typically, the recommendation in
Amen.
most cases, I know this is not a typical case, is that the minor remains in their stable, permanent, primary living environment, and that the parent who does not have primary custody do the traveling, at least for the majority of the visits during the year.
I'm not on camera, so you need to do the clock it little thing with your hand. Clock it. Okay, sorry.
You're good.
And did you consider again making that talking about the same piece of your recommendation? Did you consider it would be important for W and his new half sibling to have a relationship?
Yes, I did.
But I guess strike that. Did Dad say when he had the discussion with the school director about any concerns that the director had regarding W's development?
Dad said that they did not. When he spoke to the school did not have any concerns about speech or development, but definitely speech. I can't recall if he said development, but we did talk about the speech. And they said no issues, everything's fine. Sorry.
And is the director, as you understand, based on what he told you about this person, is the director the same thing as W's teacher, or is this like more or less a manager of the facility?
So my understanding from speaking to the director, she's the director of the school, but she does have she's not the active teacher, but she does have ongoing contact with W, is how I understood it.
And I don't know if this is an appropriate question for you
Then it's
or
not.
for the court, but since your recommendation was just for Santos not to be around, is it possible that you could have said, but I would suggest, like, sorry, strike that?
Yeah.
Let's ask it in the hypothetical. Is there something that you would have recommended attached to the Santos recommendation for him and Brianna to overcome that recommendation? Meaning, is there anything in your professional opinion that would help to remove that order or recommendation eventually?
Well, just focusing on mother, I would say that minimizing the amount of incidents that are being found as domestic violence by the court, as well as just um, dosing her dosing her insight on what domestic violence is and what may be possible triggers and what it looks like, because a lot of people have no idea what it is, but it's not one way. Just keeping focused on the mother, right? I can't really speak for a party that's not involved as far as like what he should be doing. I think I would defer that back to the court. Also, let me add in here. I think that's what all of this is trying to say is keep the focus on the mom. Let's get focused on the mom seeing the child. Let's get focused on if the mom can see the child. Why is Santos even being in it? But this lets me know right now why the judge said in August Santos's name is not even going to be mentioned. Do not bring him up. Don't talk about him. His name will not even be mentioned in this court unless you guys have done a shit ton. She didn't say shit ton, but a whole lot of couples counseling, and we'll decide at that time because that's crazy. Okay, sorry. Go ahead.
And then Bree's attorney, all right, no further questions. Then the judge, anything else based on what she asked? Then John's attorney, just briefly. Then John's attorney, you mentioned at one point in time my client's sister and her husband, at least for some period, were living in the household with W at the parental grandmother and my client. Did you get a chance to talk to father about the bond W has with aunt and uncle?
We briefly talked about it. He said, if I'm recalling correctly, he said that his sister moved back into his home specifically for W to help with W. He said that he described them as best friends. He described, yes, the relationship between his sister and W as best friends.
And I understand they don't live in the home currently, Is your understanding that they live close by and still see W in Texas, or do you know?
Oh, I think he said they're still close by. I don't recall the distance, but he did say that they were still close by.
When you were asked, you said one of Dad's concerns was location. Did you understand that to mean specifically related to the issues of violating the orders and lying about W's location? Then the judge, wait.
Yes, that's
Then the judge, I don't understand the question. Then Bree's attorney, objection, assumes facts not in evidence, misstates prior testimony. Then
I can
John's
Oh,
attorney,
sorry, I jumped the gun. My bad.
I can rephrase my question. So you were asked about, or you had testified rather, about Dad had mentioned, his primary three concerns, and one of those concerns was summed up as a concern regarding respondent's location. And so my question is, the specific concern regarding location, did you understand that to mean issues with respect to respondent not being truthful or forthcoming about W's whereabouts during her her parenting time?
Yes, that's how I understood it. And he described it that way in terms of not being truthful when it comes to disclosing where he will be, the location where she has him under her care.
Another concern, I guess that was brought up, was that Mother's fiance is using rugs. Was there also concern about Mother's fiance drinking, correct?
He didn't say that specifically. He said more using rugs. The father himself didn't. I don't recall him saying. He did mention there was underage drinking, but when we were talking about specific concerns, he mentioned rug use.
And based on
The
what is that,
cleats. The
Cletus?
cleats. Yeah, the cleats report.
Cletus record that you ran, Mother's fiance was, among the things he was arrested for, he was also arrested for underage drinking, correct?
Yeah, sorry. This is what mother told me. It was on the Cletus, yeah.
Then the judge, the sense I got from the testimony was that Mother represented that the arrest was for underage drinking. Her review of the Cletus revealed that there was a domestic violence charge. Then John's attorney, okay, got it. Thank you for clarifying. Your conversation with the school director, just to clarify, the school also, or the school represented to you that if the mother wanted to obtain access to the parenting app, she had to do that through the school, correct?
Yes. They said she would have to go in person, yes.
Okay, I have nothing further. Then the judge, all right, another couple quick. Oh, Miss Fonseca, did you want to ask any other questions? Then Bree's attorney, yeah, the school thing. So the woman that you spoke to said that she had communicated this information to Brianna before, that she needed to go there in person to get what exactly did she say?
She said that she told her she could not give her the access to the app over the phone, and that this is typically given to parents in person. Sorry, I'm just backtracking. I'm trying to refresh my memory. So she did say that Brianna was specifically asking for access to the live cameras. That is also something that parents need to request in person. That she was not asking for access to, at least with her, to the parenting app. It was the director, is what the director said to me. So she wasn't asking for access to the parenting app like you're supposed to. She was actually asking for access to the live camera feed.
And did she explain if this live stream was part of the parenting app we're talking about, or did she make it sound like we were talking about two separate applications?
I understood it as two different. I don't know if it's an application, but it's two different access accounts.
And did they just need to make a physical and did they just need to make physical contact or see Brianna in person, Or did she really explain why this personal trip was required? Then the judge, look, to me it's obvious, so I'm not sure. She never met her, and when she talked to her over the phone, she claims she was abusive to her. Whether you agree or disagree, I think this line of questioning is not getting anywhere. Then Bree's attorney, okay, no further questions. Then the judge, okay, I have a couple of quick ones. You've been doing this for a long time, so you know because you work for the court, right?
Aye.
Go ahead. How long have you been doing PPAs to the court?
For the court, it's been about 2.5 years.
So do you know the difference? I don't know if you know. Do you know the difference when they say a Montenegro final order versus a temporary order? Or do you know the difference between that?
I've heard it a lot. I can't tell you that I know the exact difference. I know that I know what a temporary order is.
The reason why I ask is, and you mentioned when you've done this when children are younger, you recommend, again, having the child fly to the parent as opposed to the parent flying to the child. But you know, when W's 2, he's in school, but he doesn't have to be in school. At some point, if Miss Olson goes to visit him, she can take him out of school for a week, and it's probably not going to be a big deal. But at some point, he's going to be 5, and he's going to be in TK, pre-K, and then he's going to be in kindergarten. And so, obviously the order's kind of set. When Miss Olson goes there for a week, if she wanted to, she could be with him every day. She could take him to an amusement park. She could take him to the park. She could be with him all day. But let's say 3 years from now, he's in school. He's in kindergarten. She flies out there for a week. She's only going to be able to see him after school, and maybe he's going have activities. So do you anticipate that these would sort of, absent nothing else changed, that these would be the orders for some near future? Or do you anticipate that there might be an opportunity where they might be changed because of W's schedule or Miss Olson's schedule, or the fact that she may then also have a young or older child that may need to be with her? Does this make sense?
Okay, so really quick, before I read her answer, I don't know what it is, but that's every child. When they're in school, even the primary care parent just gets them after school.
Yep.
I don't understand that. She's like, but what then are they asking for her when the child's in the TK pre-K for, right? It's three pre, four pre or pre-K, and then kindergarten. So by next year he'll be in pre-K, right? Or 3K. That's with every child. Whether you're the primary parent or the visiting parent, you only have them after school. Anyways. So she says, I think so. You're asking if this is where the order, or if this were the order for the next few years.
Right.
And how do I anticipate the parenting would work out?
Yes.
Her time with him? Well, I would assume that if this is going to be the order for an extended period of time, that it would be beneficial for them to have a set vacation, holiday, summer, whatever you want to call it, schedule. In those cases, then I would be able to craft out more time. I don't know if the court would be inclined by then to allow the minor to travel to California for visits and family vacations. Those would be taken into consideration, and then that. But yes, a vacation schedule, holiday schedule would hopefully help mediate for that. Just real fast, typically, guys, once people go into a school schedule, everything changes, right? Then typically the parent living out of state, this is only for parents that live a distance away, right? What happens is they go to like a changed schedule, like an altered schedule, like basically a holiday schedule, summer schedule. They get like spring break, a month out of the summer, a week in Christmas, and like every other Thanksgiving, like those type of stuff. That's typically how it's done. Okay, sorry, go ahead.
No, you're good. So you're saying if these are the orders for some period of time, And as W gets older, you would anticipate that it would be necessary to somewhat tweak it to provide for vacation schedule and maybe the opportunity for W to travel to see his mother in Los Angeles, correct?
Yes, that's correct.
Okay, anything else? Either party? Then Breed's attorney. Last question. That just triggered my memory about school. Dad says that W is full-time at the facility. Did you say that Dad said the schedule was Monday through Friday?
Yes, he said he's now going daily, so that was also a concern by the director.
And when did the schedule change from part-time to full-time?
I believe he said within the last month.
And did you
Very recently.
ask Dad if he communicated that change with Mom?
I did not ask him that.
Okay, no further questions. Then the judge, anything else? Then John's attorney, I have nothing further. Then the judge, okay, you've been, I don't even know that word.
Immensely patient.
Eminently patient with us.
Sorry. Eminently patient.
Eminently
Sorry.
patient with us. We greatly appreciate it very much. Thank you so much.
Thank you very much. Goodbye.
Then John's attorney, my client would like to take a short break to use the restroom. Then the judge, it's going to be short. Let's say 4:10. Then John's attorney, thank you. Then the judge, and while we're doing that, do you know, because I do, I'm not going to. I want to hear from both of you. What I want to do is ask you on the record. Then John's attorney, understood. Then the judge, are you guys available May 5th in the afternoon?
Do you want me to do the attorneys again since the other one's gone?
Yeah.
Okay, that way you're not reading them. John's attorney, let me double check. Bree's attorney, I think I have a doctor's appointment that day.
In the morning or afternoon?
In the afternoon, let me check. John's attorney, I can do May 5th and then.
Well, if Miss Fonseca is not available, and then discussion off the record between the court and counsel, then the judge. I don't know when you both got the PPA. Probably didn't get it with enough time to process.
Miss F, Bree's attorney, 6 minutes before our meeting and time.
That's the way it works. Unfortunately, I want to give you an opportunity to process it, review it, evaluate it. That's why I didn't want to say, do you agree or not agree? I don't want to speak for Miss Fonseca. I guess it's, at least initially, it's not necessarily something she fully agrees with, and I want to give you both of an opportunity to speak your piece. Tell me whether you agree with it and tell me where you don't agree with it. And then my intention, because I was thinking about this, I could spend 30 days writing a move away order, or I could get a court reporter on the record, go through all of the LA MUSGA findings.
It's the La Musca findings.
Yep, what you said. and make and craft my decisions sooner rather than later. And respectfully, and especially if it's a move away order, 30 days, etc., etc. So rather than do it that way. So my goal would be the 5th is that you both argue. Is there any additional testimony you want to provide today? Or then let both of you argue. And then when you're done arguing, the court will announce its decision. I can go through the factors. But there's this large issue, and I know Miss Budnick gave me one case that's current, which I did not get a chance to read over the break. I had ex partes. But if there are other cases you want me to read, I think here's if you, and I'm not going to require either of you to tell me an answer today, but let's say hypothetically speaking, you both stipulate this is the final custody order, then it would just be determined by the judge. And if you don't, then you have to have a trial on everything. Trial on custody, trial on attorney's fees, and a trial on child support. What were you going to say?
this is John's attorney. I believe, and again, I'm just speaking from memory, so I apologize if I later find out that I said something incorrectly. But my understanding is that the court can also, oh my gosh, can also
Bifurcate?
bifurcate, bifurcate. I have no idea. Issues on its own motion. And so I think this would be an appropriate scenario, even if there is not a stipulation for this and the custody orders that are included in a judgment. For the court to make that determination, because, and again, sorry, the case I've read, and I mentioned to the court, once there is an initial best interest determination, a contested custody hearing, evidentiary hearing, and the standard going forward to modify that custody determination in is change of circumstances.
And the best interest.
John's attorney, and change of circumstances. And then if the change of circumstances is shown, then the court conducts the best interest analyzes over everything. So I think there is no reason to make these the final custody orders, given that if we were going to do a trial on all issues in 4 months, at that point, the court is still going to be assessing, was there a change of circumstance? And I think it just, absent proving a change of circumstances, the court order to trial are going to, excuse me, are going to be the same as what they are today. Unless, obviously, we go to trial in 2 years, the significant period of time where it's more likely to be a change. But in the next couple of months, I don't see. And also, just for the finality of the orders, we just spent all of this time in court addressing a very, very comprehensive hearing of custody. To not have these be the final orders and have us have the retaliate the issue, I would just ask the court, even if we don't have a stipulation to bifurcate, whatever, the issue of custody and make whatever orders are made the final orders. Then Bree's attorney, it would be a change in circumstances, evidentiary burden at trial if it's not deemed to be the final orders. And typically, when a PPA is set, the court asks, do the parties want to potentially treat this as a custody and visitation final orders? Then, therefore, do you stipulate to such? So it's known up front when the PPA is set that it is what was set, that is what it is. Oh, that is what it is. That this today is our final trial. That was not done.
That is correct.
Bree's attorney. And you would know Monday and Friday, or you would know from Monday and Friday, our concerns about legal custody and just the empowerment that we see that dad feels as far as just almost treating my client like she doesn't exist in the child's life.
Okay.
Ma'am, John doesn't do that. Bree acts. Your client well, not your client no more because you fired her ass, but your client acts like she doesn't exist in the child's life. Sorry, I'll continue. And I just don't want the passage of time under that order, assuming that's the order that remains. And that I assume that that's what it will be, because that was the evaluator's recommendations. The passage of time is just going to make this situation worse. I mean, yes, we've got a recommendation for therapy in the court, makes the order. Hopefully these parties change in positive perspectives and therapeutic court or progress. But that's not the position that we've been in since August when the legal custody order was made.
Then the judge, okay, so real quick, I think we're here really, this was initially an RFO from way back. Like, didn't dad file an RFO for a move away?
Sorry. Bree's attorney, within the first month of W's life.
Dad filed an RFO, basically, and a move away order, or a move away from the beginning. And we had that. And then we had a lot of stuff, for lack of better term, happen. We had the trip to California with W, when she took W from Texas to California. And then we had, excuse me, sorry. And then we have 2 DVROs in between. And so everything was sort of, that RFO was put on the back burner. But if we never had the DVROs and we never had anything, we would have addressed the RFO/move away with a PPA. So my sense is this is still part of that. It's just gotten delayed. And I think from Ms. Fonseca's point, we've never done a trial or on visitation. We really just, I'm with you. I'd like to avoid it from the resources, but it's her right if she wants to. And I also say, the PPA was sort of going to happen with the RFO. We had to delay it for so many months, nearly a year, with everything that was going on. But to Ms. Fonseca's point, if she never stipulated, the court never asked her to, shame on me. But also, everything kind of I kept focusing on everybody, and because we need to keep these orders. But my sense is if we were going to have a full blown trial, all of those emails and things like that Ms. Fonseca said she wanted to get in, and all of the other evidence, which I said I didn't think we have at this point. She had another opportunity to revisit some of that and say, this is why this is relevant for permanent custody. And while I recognize the court can bifurcate custody and visitation if it's likely to simplify the other issues. And I know that's what Rule 45.3906B says, including that in the custody and visitation, but it's funny. The simplification part really in the custody and visitation sounds like it's really simple. Once that gets resolved, both parties, at least my sense, is that the child support is going to be maybe less difficult. And that's where they potentially may want to go to private mediation. Oh my. And I just think, sort of you showing me a case that says I can force file orders down Miss Fonseca's throat when I don't think, but for emergency orders, we've ever had a temporary custody order that were part of a full-blown evidentiary hearing.
Oh, sorry, Miss Taylor, or John's attorney. Well, these orders will be these orders will be orders issued as part of a full-blown evidentiary hearing. Both parties had testified. We've had a PPA. I don't want to waste the court's time. I respectfully disagree. And I think regardless of if these orders that are issued, if it's on the second, or if you need additional time after to put something together and think about orders, whatever orders are issued after this series of evidentiary hearings that have just happened, those orders cannot be modified unless there is a showing of a change of circumstance. So from a judicial economy perspective, I don't see why we wouldn't put those orders in a judgment when a judgment likewise would require a showing of the change of circumstance to modify it. And so I respectfully disagree, but I don't want to belabor the point. And then Ms. Fonseca, an evidentiary hearing can be set for a number of reasons. An evidentiary hearing does not mean it's a trial or a bifurcate hearing on XYZ issues. So I just heard about the case for the first time when she gave me the citation. So I'll certainly read it and report back on the 5th. But without reading it, again, it just doesn't make sense to me. That's why, wait, to me that we are claiming now have an evidentiary hearing means that this is a, oh my god, is a bifurcated trial on XYZ issues when again, we have evidentiary hearings for a number of reasons. She just says the same stuff over and over.
Yep. She
And
talks
they
in
are,
circles.
yeah, and they are never usually marked as final orders hearings. It's just something that requires more of the court's time, or somebody required a 217 hearing and the court, made its findings and allowed the hearings to go forward. There are a lot of reasons for an evidentiary hearing, and I agree with what the court said. Reverse move away or move away are always treated with PPAs. So, since Dad's RFO was pending since the first month that W was born on a reverse move away, eventually at some point, unless the RFO was withdrawn, which it never was, it had to go to a PPA. But like the court said, this is a PPA about a reverse move away. We just finished the evidentiary hearing about a 3044. Neither of these are trials or custody visitation. They are subsidiary issues of that larger umbrella. If you want to describe it that way, but like I said, and like the court echoed, we never stipulated to that. The court you never asked us how to stipulate to you to bifurcating this and making this a trial, and we wouldn't have, honestly, with how quickly it was set. There would be no way I could have done discovery and prepared for a full blown trial within, I think, what are we, like a month? I think you gave us since. I think you gave us since you made those arrangements to get us in so quickly to the evaluator.
Then the judge. Here's my thought. I've driven both of you in some respect. Is that I'll read the case of inquired and
Enrique.
other Enrique. Oh, and other cases before the end of the day. But there are other issues that have to come. The attorney's fees, the child support should just go to a trial, and I can set trial dates. But I don't want Miss Fonseca to think I'm setting a trial a year from now.
Miss Fonseca, no. And just for you guys, really fast, for you guys that haven't been with me the whole time, they already settled on the child support, and there will be no child support. John's not requesting child support. Bria has to pay absolutely no money. So just an FYI. Okay.
Then the judge, this case is a 24 case, and I see some dates at the end of August, and that gives you guys maybe enough time to do your discovery and all of that. So you're going to get my order, next week. You're both here. I'll hear it orally, and I'll tell you what it is. But then to Miss Fonseca's point, it's not fair to make that the final order. And if I'm not convinced that Enrique M, that's fine. But we're not going to go to a trial a year from now. I can set the trial in August.
But this is John's attorney. So I suppose my question, as phrased in another way, would be, okay. The court's going to make an order on the new, right? W is going to, there is many states that he lives in, right? Texas will be and I don't think there is a question of W living primarily in LA. So Texas is going to be at least his residence 50% of the time. He's not leaving Texas. When we go to trial in August, not even 6 months, the court certainly isn't going to have another PPA.
No.
And then John's attorney, another evaluatory testify?
No.
John. So the limited evidence we would be presenting would be what has changed from now to August. The court isn't going to be looking at what happened, like this was the opportunity to put everything forth to the PPA evaluator as to, and then the evaluator testified as to the relationship dynamics. The parties can now testify. I mean, I don't need to call them. Miss Fonseca has. I can choose not to call anyone else. So I think this is the opportunity. If the parties have testimony to provide in the best interest, this is a chance to do it.
Then the judge, well, hold on a second. We sat on this because I punted. We haven't addressed the elephant in the room, which is 3044.
John Attorney, correct. For those that don't know, the 3044 is the DVRO. Okay, sorry.
You're good. So that's part of what the court is going to do. And I said earlier this week, I need to hear from her before I decided whether the 3044 presumption is overcome, and made the finding at least the factors listed. And then there's additional, so my 4045, you're going to have a ruling from the court as to whether or not the 3044 presumption has been overcome at this time. Let's say I find that the 3044 presumption has not been overcome. Ms. Fonseca still has an opportunity to demonstrate to me by trial. She gets another bite at the apple. That now 304 presumption has been overcome. So that's going to change. Also, there were recommendations from the PPA that maybe I agree with them, maybe I don't. But the initial thing is for Mr. Giesi's therapy, Mrs. Olson to go into therapy. I'll be frank, one of the things I'm thinking of is perhaps ordering her to do a domestic violence class herself. So if she shows me proof, I mean, that's the classic way that many times people overcome the 3044 presumption, where the domestic violence, that they are taking a class. Look, we can argue this later. She's in the room and not up to her. I'm very concerned. I understand it's an arrest, but in addition to the court making a finding of Miss Olson committing DV against her partner and Mr. Giesi, we have the factor, of the Family Court Services facilitator saying that Mr. Salazar Santos was an active person, and that's of concern to this court. So there is additional evidence that can be presented. I'm not going to tie your hands as to what can or cannot. We're in this very strange posture because it's like a moving part. We had the RFO for move away. Then we had the issue with her taking the child back. Then we had multiple DVs. Then we had multiple ex partes and stuck in the point. So we're kind of back to the point where we're having everything. And then respectfully, we had this, I know I said some things. Well, Miss Budnick didn't deliver on certain things, but she did deliver on other things. And she did say, I'll show evidence of DV. And she did show that. So there's been a lot of development to get us to the point of the PPA on the evidentiary hearing. I still see a potential, not as a final order. And so we set it for trial, but I'm not saying to set it for a trial a year from now. And so you guys decide what you want. And so if I make a finding next week that she has not overcome the presumption between now and trial, Miss Fonseca will have the opportunity again to show the court that she has overcome the presumption. And hopefully by then, I hope that, Miss Olson gives birth to a beautiful, healthy baby, and we'll see what happens, with that and all of the issues there. So I don't know if we want to pick trial dates now or wait until next time.
Bree's attorney, that's fine. John's attorney, I think it would be helpful so that dates don't fill up for us to tentatively set dates now with the reservation. Obviously, I would like the opportunity to present a full argument to the court on the 2nd with arguments that with regards to what I believe is a specific procedure for mom making changes to whatever orders are issued.
Okay, so I have the entire week of August.
Bree's attorney, wait, hold on. Was the 5th at 1:30?
Yes, 1:30. I have the entire week of August 24th open with the exception of the 27th, but I'll send that trial out if I have to give it to somebody else. So I have the whole week of the 24th available.
John's attorney, I'm really open in August, so I can do that week as well.
Does that work for you as well, Miss Fonseca?
August 24th, yes. Not just August 24th, bitch, the whole week. She just said that. Are you listening? Listening ears. Oh, never mind. You don't count anymore. You're gone. Okay.
So let's do that whole week. And I have a trial on the 27th. I'll just give it to somebody else.
John's attorney, it's the week of the 24th, you said.
Yes.
The 24th, 25th, 24th, the 24th, 25th, and 26th.
And the 27th and 28th. We have a whole week. One of the things I think I'm going to do. Well, Michael, you figured out now how to put people in the waiting room, right? So I'll allow parties to appear remotely if they want, as long as they tell the court beforehand. And we're going to make it so they can go into the Michael has figured out where they go into the waiting room, so they cannot invite, so other people, uninvited guests, do not participate. The only issue, I will tell both of the people what I have found sometimes difficult when you have a party and a witness who are remote, that if you want to show them documents, it's going to be very difficult unless you're going to put them on the Elmo. But it's difficult, okay? So I would say my tentative right now is to say we'll set it for trial on everything. That will give you the guys the opportunity to go to mediation, do all of that, and we'll go from there. All right. So any other cases besides Enrique M?
John's attorney. That's the case that I pulled. But honestly, if you read Marriage of Burgess, La Musca, Marriage of Montenegro versus Diaz, and all of these cases, and the distinction is,
I'm having trouble hearing. I don't mean to be rude, but when somebody else is talking, it's hard for me to hear. Go ahead.
again, John's attorney, all the case law that I've read, I haven't found a single case that supports conducting an evidentiary hearing on an initial best interest determination. And then after that ruling is made, having that order not be deemed a final custody adjudication. I've not found a single case that supports what you're saying. And the difference, and I think this is the distinction, is there is extensive case law that allows the court to make changes to a parenting plan based on best interest at any stage of the case. But there is public policy, and largely public policy, that supports and urges for and seeks to obtain stability. And stability is one of the most important things for a child, right? And that's throughout these cases. And the point is to,
Let me ask the $1,000,000 question.
yes,
Let me just cut to the chase. I'm going to announce this in May. Your child is 3.5 months away.
correct.
Short of legal custody and Miss Fonseca, the thing about Miss Fonseca, she knows when to hold them and when to fold them. I don't believe Miss Fonseca is going to be arguing by August that the change of 50-50 physical custody with W between Dallas and LA. Am I correct in that regard?
Wait, sorry, Angie cutting in here. Did the judge just foreshadow that Miss Fonseca was not going to be there in August? It just said, I don't believe Miss Fonseca is going to be arguing by August. She sure ain't, because her ass ain't part of this case no more. Sorry. I'll finish reading. I apologize. I just had to put that in it. That's crazy, though, right?
Yep.
Okay. Miss Fonseca, I'm now fired. I fired my client. I'd say not. She's going to have a newborn barely at that time.
Right. So the most we're talking about is legal custody. Let me finish, please. And Miss Fonseca has said all along her concern is legal custody, that this is really more of a legal custody issue. That's the sense I got.
So I'm Bree's attorney. Legal custody and evidentiary having visitation in California. Denied. It doesn't say that. That was me.
But again, that's to Miss Budnick's wow. But again, that's to Miss Budnick's client. If he has primary physical custody, changing in visitation is not a material change of circumstance because that's not a change in custody. It's just a change in visitation and the amount. That's always going to be a best interest to him. It's not going to be a material change in circumstances because you're not materially altering the physical custody because you're saying it's the primary. So we're back to legal custody. And so I'm just saying if the court finds on the 5th that she has not overcome the burden, I just, I would review the evidence. But I'm just saying 3 months from now, I'm going to give her every opportunity to present additional evidence. I've heard a lot of it. And just because you guys want to know, Miss Fonseca has made a lot of arguments and asked questions while, isn't it true Mr. Giese excluded her, didn't include her, didn't let her know about this stuff, and the court's response all this time has been under legal custody, under sole legal custody. I don't believe he has to do that. And there wasn't I'll let you argue that. And there wasn't a court order that required him to do that. And frankly, the more questions I hear, and this is a concern, I'll be frank, it seems like it was an interesting from the witness. Number one, he said Miss Olson was abusive to the staff. And I know you'll dispute that when I hear that. And I know you'll dispute that when I hear from that. But it seems like the concern was not that she has access to the parenting app. The concern was that she wanted access to the live stream, which again is a concern for this court because, and the argument, well, wasn't it true that he wouldn't give her access? And maybe you want to show me the Our Family Wizard messages. But he can say, no, I didn't want her to have my access, my logon. And that makes sense. And then when they said, all of these questions about the daycare saying, well, they needed to meet her before they could give her access. Absolutely. That makes all the sense in the world here. So I haven't heard a lot so far. And maybe they'll show me a bunch of different evidence that causes court. I don't want to say concern, but we have someone with sole legal custody. And we know if he had permanent sole legal custody, he gets to move wherever he wants with the child. And they place the burden on them to prove detriment. And we're not there yet because we don't have a permanent order. So now we've got to do the LA
The
Musca,
La Musca factor.
the Lamusca factor. And I'm just saying, look, nobody wants to see this case get. I don't want to be rude, but I'm also trying to, and maybe there's an issue of is it filed for appeal purposes or whatever. But 3 months later, you're going to have a final order. Either way, that's appealable. And I don't think much is going to change between May and August.
John's attorney. That's exactly why I think it's the best interest of everybody's time and resources to make the final orders now. I agree with Your Honor. There is going to be very little change between now and August. Why are we forcing these parties and counsel to spend 5 days in court, incurring fees, wasting court's time, taking up calendar space and other matters when, by everybody's account, the only thing that they're basing a potential to argue about is whether in August there's been some kind of change to render the 304 rebuted, or a change in legal custody. We can deal with the visitation anytime she files an order to say, let me have my visits somewhere else now. I'm not changing the custody order. I just want to change in the schedule. So why? We've been in court so frequently on this case. Why not put it into the issues where we can? Why why come back in 3 months to do the exact same thing we just did? Bree's attorney, or no, Fonseca. Yeah, Bree's attorney. Not exact same thing. She's been statutory, right? Or she has statutorial, right? And again, this is not a bifurcated trial on custody and visitation, period. And I'm just using Westlaw AI Precision to run the case. Wait a minute, what?
She's using AI to run the case?
I had to back up. I was like, wait a minute. I'm gonna read that again. And I'm just using Westlaw AI Precision to run the case. And it's just another case about the standards of visitation change versus custody. Oh, probably one of the cases that she cited in case law, I would assume. Visitation change versus custody change, and the best interest versus change of circumstance. So again, an evidentiary hearing is set for a number of reasons all the time. And evidentiary hearings are not automatically final orders, and that is not what this case said. And I also don't want it minimized that it's just not a big deal. It seems like we're aloof to the fact that the legal custody is still temporarily with dad and how that's played out. We were not going with that line of questioning to say dad violated legal. Stop it. I very much understand understand what sole legal custody orders mean, but the co-parenting relationship is part of the Lamuska factors, and it's part of the bigger analysis of best interest. Sorry, before you go on, Judge. Again, I will say, you can't co-parent with the parent that doesn't parent. Bree's made
Amen.
it obvious. She does not want to parent. She wants photo ops. She wants to be able to take pictures with, but she doesn't want to co-parent, and you can't co-parent with a parent that doesn't parent. Okay, go ahead. Sorry.
The court. Yes.
Bree's attorney. So if we have somebody who is almost weaponizing sole legal to the degree of we're not telling mom anything when we do tell her.
The judge. Okay, I don't want to argue this substance.
Bree's attorney. Okay, but like I just wanted my opportunity to be heard and create the record for my client. Seeing her child in California, where her other child will be living with her, is very important.
I understand that.
Bree's attorney. Being involved in legal custody decisions is very important.
I understand that. And I also understand that she feels she didn't have a full opportunity to explore that in the final order. I get that. So your question is, well, why not? I understand. I understand judicial economy, and I understand all of that. But I got to balance the judicial economy with due process. And everybody feels that they have a right to be heard and to present all of their evidence. And look, if I decide that the burden hasn't been overcome, Miss Fonseca is going to object to that. I understand that's her right. And then to say, okay, I'm finding it hasn't been overcome and we're done. End of story. And you don't get any right to revisit it as a final order, as a judgment. So if I announce on Tuesday the burden hasn't been overcome, and I'm giving him sole legal and sole physical. Oh, and by the way, this is your final order. You're done. I'm not sure that's necessarily due process. I could be wrong.
Miss Bennett, Taylor, so John's attorney. Well, there are,
Okay,
John's attorney. Once the issue is litigated and ruled upon,
I need you to give me case law. I'm not trying to be rude.
Taylor, John's attorney. No, I'm arguing it on.
Let's argue it on because I'm going to look at this case. Well, are you going to give me other cases? Because I do have a weekend to read between now and then.
Miss Bennett, John's attorney. The case I read, this is the most.
Give me the case.
I said it previously. I think the Montenegro addresses the issue. And then Bree's attorney. Burgess addresses the issue, and what's the other? La Musca actually addresses the issue too.
Okay.
So John's attorney, and by issue I mean the distinction between the change of circumstance versus the best interest. What is considered a final order versus what is not a final order.
I will read over those cases.
And then Bree's attorney. So I forgot that we are talking about what we were talking about earlier when we were being annoyed with her. She was asking about, wait, what? Who are they annoyed with? Let me read that again. So I forgot what we were talking about earlier when you were being annoyed with her. She was asking about mediation.
Counsel.
I wasn't trying to be disrespectful. No, the fuck you were. First of all, I don't even know who she was talking about, but that's disrespectful. I wasn't trying to be disrespectful like my client is.
I know, but hold on. When people say you're getting annoyed, or when you say, I don't want to upset the court, you know I'm not annoyed, okay? I'm not annoyed. What the court is trying to do is ensure that all parties are heard. I can't hear Miss Budnick when you and your client are whispering loudly. I'm not annoyed, and I'm not going to rule against you. Let's talk for a moment as it relates to the court. I just brought it to the attention because I have a court reporter. And so, especially when I have people online and they're trying to hear and she's trying to, so it's not annoying. What I'm doing is what I'm saying is it's making it difficult for the court to hear. I'm trying to preserve the record and my ability to hear everything that people are saying. Go ahead.
Bray's attorney. Right. They have mediation in a couple of days, which is attached to the trial setting conference request that she filed. So obviously, they would still go to that mediation because that's required before trial. But we are taking the 5:20, 1:30 p.m. off calendar since we set the MSC Monday's hearing, and today we set trial.
Okay, we took all of those dates in August, right?
Bree's attorney, right. And you did an MSC, remember, on Monday, also for August, right? And then John's attorney, yeah, I believe the MSC was done August 6th or 2nd from memory.
Okay, let's do this. I'm going to take the 5/20 date off calendar, and on 5/5, you'll all remind me to set a TSC between now and the trial date.
John's attorney, could we schedule? I like the idea of.
It's 4/28. I cannot make my staff go over.
It's a TSC, it's a trial setting conference.
That's fine. We'll see everybody. We're not keeping the 5/20. We're keeping the mediation date and we're keeping the TSC. But there is a TSC on August 5th. And then discussion off the record between the court and the clerk.
Miss Bunnick, thank you. Have a great afternoon. I need all parties that have all cameras off.
Proceedings concluded at 4:28 p.m.
And then the last page is just the the person who took up the notes that took 18 years to get it to us. All right, that is the end of that. We can turn the comments back on, and we'll have a brief discussion way past my bedtime, which is why I'm over here yawning like old Grammy. No, if this was on Tuesday, I would be more refreshed. I'm curious to know all of your guys' thoughts, opinions, whatnot. I'm curious. I want to know. She's cooked. That was a lot. Didn't breathe. Miss mediation. She did miss mediation. Yeah, didn't even go through. Shooketh explains why she is setting the stage that she is breastfeeding. Facts. Will the screenshots be posted on your page? I would like. No, I don't. You guys, I don't ever post any documents at all. I don't.
She
There
will
is too
post
much.
this. I was going to say, you will post this all on YouTube for people who missed it.
Yes, I will post this on YT, but I don't ever post any documents. There is a lot of personal information that we skip over, and I would be terrified that I wouldn't get that. No, so I don't post them. So next court date for this was is May 5th. I have ordered the May 5th transcripts. They're in the process. I will let you know when I get them. Please don't come in and ask every day like we did about these. As we can see that they take a while to get to us sometimes, but I have a feeling I think these ones are almost done. So I have already ordered and purchased the May 5th orders. So as soon as we have them, I will let you know. Good night for everyone who is headed out. Yeah, I think it's very interesting. And as a reminder, for those of you guys, we already talked about it, so it's not really a spoiler alert. Bree did not overcome the 3044 presumption. She did not. Matter of fact, they found her guilty of 3 different things. So she did not overcome the 3044 presumption, which means he's going to be able to keep the sole legal physical custody. He does not have to turn this stuff over. All of the good stuff, right? Well, you guys are still in here, where there's still 3.2K of you guys in here, make sure you guys are following me so that way you guys get the notifications for when I have the next set of documents, which again will be soon. They go to trial August 24th for 1 week. I see that they've worked out the system. I cannot say this enough, you guys. Please don't try to log into their court cases. That was really crazy. Dang!
Thank
Good
you.
job. Bailey
Thank you,
deserves
everyone
it.
who has also gifted me. I appreciate it.
Yeah. Are we confident John's last live? In order for first of all, the thing with John's last live, that's a reactive abuse. Like when you're poke, eventually you're going to say something. No threats were made, no nothing, one. So I don't think it's absolutely going to react. Yes, I will do on tomorrow. I will do a recap of all of this. No, I don't think it's going to affect it. And not only that, she's her own attorney now. She would have to file in and do all this. She's not doing that. Yeah. Thank you guys. Thank you guys for everyone who is thanking Bailey and I. Does anyone have any other questions that they want to ask? Did everyone send their daily heart me's? That's important. We got back up to 1,000. I appreciate it. We're at 1.3 million tippity taps. What's your question, Star? Thank you, you guys. It is a lot reading these court documents because you want to read just straight through. But I've noticed in doing this, I typically would read like legal forms and stuff, not transcripts. They never complete a full sentence. We'll read a sentence and it will start a sentence, go into something else, and then end another sentence. It's very confusing.
And then someone interrupts, and then you're going back to the old conversation.
Yeah. Did the judge say they are opening the courtroom for trial? No, not opening the courtroom for trial. They're going to close it. Matter of fact, they're not going to let people in. She said that they can actually appear remotely. First, in the beginning, she said that you guys have to appear in person because we don't want this remote stuff going on. I lost count how many people tried to come in. Again, that's ridiculous. I don't understand why people do that. And then she said, okay, we figured out how to close the courtroom virtually so you can appear virtually. Carding! Thank you! She wanted to breastfeed.
You can
My bad
tell
for thinking
from
with
like
you.
the judge too, when she was speaking there at the end,
Mm-hmm.
that she believed that Bree didn't overcome it. And you could just tell like she
Yeah, she was letting them know.
wanted,
She didn't
yeah.
overcome it. Yeah. It'll be very, very interesting. So John
No,
doesn't have to.
John needs to go to California in August. It's
Yeah.
the trial.
Well, no. Originally in this, though, the judge said that all future hearings will be held in person. Then later on, she says, "Okay, now Mike, the assistant, figured out how to close the rooms, so you guys could apply in person, or it could apply virtual, but that makes it difficult when it comes to evidence and whatnot." Where did that go? What does overcoming the 304 mean? So the 3044 is the DVRO, right? So for her to overcome that, she had to have had no more no violations of the current DVRO, and had to complete like 4 different types of therapy classes: batterers abuse class, some high conflict co-parent resolution classes, age appropriate parenting classes, which they signed up for, but they decided to split it in half. So half of it will be for baby W and half will be for baby Paycheck. So, but she already has been, we'll read that in the May 5th order when we get it, that she did not overcome it because she was found guilty of violating it 3 times. Does it matter if the DVRO expires? Well, if the DVRO expires, then technically she could still fight for 50-50 custody. Is she going to get it? No, because of where it is. And again, I really think she shot herself in her foot by having Santos go in and lie. Like, he probably went in without his black glove and his nice clothes and was like, "Oh, no, I've never been arrested. Oh, I've never done anything of such. I see my daughter every month," but gets online and whines and cries because he hasn't seen her forever, says he's never been arrested. Then she's like, "Well, I have the arrest record right here, but you were arrested right here for spousal abuse or battery against a spouse or whatever." So, yeah, it was crazy.
Well, and she like tried to push him to because she asked if he had ever been arrested while they
This
were
is a
together,
safe
and he
space for
said
everybody
no.
over here. We don't talk politics over here. Yeah, he's gonna continue to blow it for her. I mean, she's blowing it for herself. She's chose this man that cannot be around her child. She has chose that man over him forever. So, he's doing whatever it is that he can do, but that's fine. Yeah. So, yeah, the voice from the FaceTime calls was crazy. Nothing.
Well,
Nothing for
well,
the
and
But love.
I was gonna say, well, and as a mother, like I would do anything for my child. And if I was separated from my husband and we lived in different states, and my child always got sick getting on an airplane, I'd put my child first.
Right.
Like, I don't know. It's just crazy to me that Bree, as a mom, does not put the best interest of her child first. I couldn't imagine that.
Yeah, she never will because that's not her interest. So at the end, when the judge was setting court dates, that was joint lawyer. Wait, what? Court dates. What was John's lawyer trying to interject about? I can't remember now, to be honest. I'm so tired. I can't even think straight about what we did. My voice is almost gone. So I'm gonna end up leaving
She
it. Huh?
she wanted John's attorney wanted her to make the ruling today and not go to trial.
Oh,
That's what she kept pushing.
there you go. I'm gonna download it tonight. Oh, sorry. I'm old now. Way past my bedtime. You have a birthday and all of a sudden, boom, your bedtime goes earlier. Um, yeah, I will download it tonight. It takes typically 2 to 3 hours sometimes to download from TikTok, and then I promise to have it up to you in the morning on YT. Now, if I can get it up tonight, I'll get it up tonight. But It's usually like 2 to 3 hours to download from TikTok, and then 3 to 4 hours on YT. So yeah, thank you guys so much for everyone who appreciate. I always appreciate. Listen, Bailey has been riding with me since day one, reading all of this. I so appreciate that. That makes me very happy. I enjoy it. So, do you have anything else you want to say, Bailey?
No, I'm gonna go to bed. I have a
All right.
14-hour
Thank you
shift
so
tomorrow.
much. Yes. And listen, she's on a different coast time than me too, as well. So shout out everyone. Give Bailey some love in the comments. I so appreciate you doing this. This is last minute. I got it, and I was like, when do you want to do this? Tonight or next week? She's like, we'll do it tonight. I was like, okay. So I appreciate you so much, Bailey.
Of
Yeah.
course. Thank you
Love you
guys.
bunches. Have a great night. I'm gonna chat with the comments with the section for a little bit, and then I'm gonna head to bed.
Sounds good. Good night, guys.
Okay. Bye. Love, yeah, W Bailey in the chat. Absolutely. I don't know what on earth her who she's for has anything to do with this. That's not a topic. So I don't know what was going on there. Man, I don't see a whole lot changing. I was kind of shocked by that too. But in reality, you walk into a room with a stranger and somebody that you kind of know, I feel like you would. Thank you guys so much for the birthday wishes. I so appreciate that. Yeah, she's just done gave up. I fully agree with that. So, wait, what? You share what you found out before reading. I didn't find out anything before reading. I don't ever go over it, you guys, until I read with you guys. Is it? And we'll tomorrow in my live we will go back. We'll go back over. We'll talk about it. Maybe what I'll do is I'll post a video just kind of giving like live highlights. I don't know. Oh, my surprise. Oh, for those of you guys that missed it, sheesh, let me tell you. So, as you guys know, I said that I was going to order and pay for this transcript, and you guys generously donated $7 over, actually, which I sent to Bailey for like the fees of transferring or whatever. Anywho, so we got it. I was fully prepared to pay for this, and then you guys said you wanted to. So I went ahead and ordered May 5th's. I ordered it a while ago, so I didn't want to tell you guys because this was taking so long. So I order, what did I say? I said Sammy, right? Did I say Bailey? Oh my God, I meant to send Sammy. I'm sorry, I'm so tired, I can't even think straight. And so the May 5th ones should be here soon. Now, please don't come in and ask me every day. Okay, because this last little scenario with this chick, I was like, you know, but we should have them very, very, very soon. So hopefully next week we'll be reading that. And then we will have been updated. I think we've read almost every single court transcript. Now, lawyer. Oh, I know, literally, they will ask me daily. I know. But I do have them, so we will get them, and we will get a chance to read them. And from my understanding, there's some good stuff in there. So, yes. Will Bree have another chance to... No. She won't have another chance to complete it. I mean, technically, in reality, the DVRO expires at the end of August. Now, I would hope that John is getting ready to file for his extension, because he should, because it was reported that it was broken 3 times. That was put in there. The judge actually rules on it May 5th that in fact she did overcome that, or sorry, that she did break it 3 separate times, and so he has great reason to file for the extension. He's just gonna have to do it, I think, by the end of this month. And if it will be granted, which it likely would, it'll be most likely either a 5-year or a permanent. The May 5th is when we hear what the judge decides and puts into place on what we just read today. Well, love. The question was, why does she think she's going to overcome it? Bree doesn't even think she ever needed it. And like the evaluator said, Bree has an issue with discovering what is proper and improper touch or communication. She doesn't even know what DV is. She, in her mind, her actions and behavior is okay, whether it's physical or emotional, mental, shoving, all of that stuff. She's not realizing that that's DV. So, no, not a police officer testified. It was the evaluator testified. And that was huge and important because that is where we got this order. So if you guys are in here, there's still 2.4K people in here. If you guys aren't following, make sure you guys are following so you get the updates and you'll get to see the next transcripts. I will do the last transcripts of August as well. Hopefully it'll be done by then. And we're going to end up here because I am tired. So we're ending with 2.4K people still in here. 1.0, so 1K daily heart maze. If you haven't dropped yours, please drop your daily heart maze. And 1.3 million tippity tappities. For those of you guys that weren't here, I missed that clip. Unfortunately, Santos lied badly to the evaluator, and she called her out on it and says that absolutely not. I do not think he is a safe person to have that baby around. Not only now, Santos, did the judge say no, the evaluator said fuck no. That's what he said. And then they also made a note that Bree consistently chooses him over her child. Yeah, I've been talking for almost 4 hours straight. I may make a video tomorrow morning to recap. I will post the whole thing up on my YT. Thank you, Rhonda. Oh yeah, I am on a little getaway. My grandson plays baseball, so I will let you guys know. Make sure, again, it's important to follow because I put all of my stuff in my little thought box of when I'm going to be live because my lives will be different. So shout out to all of you guys who were here, who stayed the whole time. I know a lot of you guys have work in the morning, and you guys thugged it out, hung it out with us. I appreciate you guys always following me. I'm sure there's going to be clips of it absolutely everywhere now. My YT is the same as here. It's Angie W1470. I'm going to stay up until this is downloaded tonight, and I promise to have it up in the morning. Okay. Yeah, that was crazy, you guys. That clip that I saw where they're like, you have to wake the baby has to fucking wake up now. He's got to fucking get up now. He's been asleep for 8 or 10 hours or whatever. That's crazy work. If that baby had been asleep that long, I think it was like 9 hours or something. No, you have a newborn that young, you wake them every 2 to 3 hours max to feed them. Newborn fetal starvation can happen in very, very quick. 9 hours. That's crazy. And grandma was there. So anyways, we can talk about that tomorrow because, honey, I'm exhausted, okay? So I'm hopping off in bed. Okay, so we're ending with 2.2K still in here. I love you guys so much. 1,000 daily harmonies and 1.3 million taps. These are fucking savages. I love you guys so much. I will see you tomorrow.